Lordship, but he has some personal difficulty today. So, Lordship, can it be on 9th of June, Lordship?
Wait, 9th of June, yes. Okay, 9th.
Hello,
May I please, Your Lordship? Well, not yesterday we have filed an additional affidavit in connection with item number 25, Lordship.
25.
25, that is not on record. May I, Lordship, allowed to bring on record that affidavit, Lordship?
Affidavit you have already filed?
Yes, already we have
25.
25.
We'll call.
May I please, Your Lordship? Lordship, item number 27, conducting counsel. Apurva Sharma is a candidate of ongoing election, Lordship. So matter may be adjourned for today.
Ongoing.
Lawyer Association.
Oh, achha.
Report of court regarding the any cases registered against the people. That is clear.
Not received. Are there on any entry of that?
No question.
Entry must have. 70. Should it? Next. Yes. Son, when it can. Second of. Second.
May I please, Your Lordship, I have back to mention number 22 here.
22.
Yes.
Yes.
The CD was called for, but could not receive it. There is a entry.
Issue remain. Yes.
9th of
9/6 interim be continued.
Lordship, I beg to mention item number 38. I have to withdraw the matter since it become infectious. The proceeding, the petitioner has sought for the put challenge under a proceeding of NIX pending before additional session Kasa Silchar. In the said proceeding, I had order dated 8/5/2026, the petitioner has declared acquitted. So there is no purpose of this.
There is no
pending the
issue.
decision.
For the respondent, there is no issue. The proceeding was going on, but there is for non-prosecution case is dismissed.
That's it.
Anyway,
Yeah,
this disposed of. Matter is already disposed.
Disposed of.
So you are for the petitioner, you are for the
Yes.
administrator. We forgot the landed council petition also had this leadership. The landed council Mr. DP additional PP status. It is submitted by Mr. Make that has already exported. And the petitioner already got an order of it. The present petition into the matter is according to history.
My name can be recorded.
Of course.
Mine.
May it please, Your Lordship. Lordship, with the consent from the other side, I beg to mention item number 10. Lordship, I am for the petitioner. I am praying for further 2 weeks' time to file additional affidavit, Lordship.
You're for the petitioner.
Yes, Lordship.
Your good name?
A. Pradhan.
Appearing on behalf of T.
Uh,
Sharma.
R.J. Das.
Appearing on behalf of Mr. The petitioner is submitted with consent. She paid for and with the consent of the others. Stating that needs some more time to fight that action. After
2 weeks.
2 weeks. You want any date fixed? No.
Lordship,
After-
any date may be given.
Pardon?
Any date may be given, Lordship.
10th of June. So file your additional affidavit by that.
Yes, Lordship.
10th of June, in the petitioner side, file their
Highly obliged.
Lordship, I beg to mention item number 39. In this matter, Your Lordship, as both Thakur and myself, we are appearing for respondent number 2 and 3. But the brief has been taken from us, Your Lordship, so our name may be removed, Your Lordship. In item 39, we were for respondent number 2 and 3, Your Lordship.
So after taking the brief, they have engaged someone or
We are not aware, Your Lordship. They have taken the brief from us. We have no further instruction.
so you have informed the other side?
Yes, Lordship.
Other
I
side
appear for
is
the bench.
present there.
No, for withdrawing your name, let's see on the next date, have you informed the other side that we are not, you are saying that brief has already
Brief
been
has
taken?
already been taken from us. We are the respondents.
Yes, yes.
Yes, sir.
Any information do you have regarding the why
No, Lordship. We are
engaging
not.
any other counsel?
No, Lordship. We are not aware of that.
You, Mr. Rajkot,
Virat, well.
heard Mr. B. Rajkot, the learned counsel, reading the respondent for 2 and 3. And also heard Mr.
J. Lotha, Lordship.
J.
J. Lotha, Lordship.
J. Lota, appearing for the petitioner. This, so it is submitted by Mr. Rajkot that the respondent were, or they were appealing for the respondent that brief had already been taken back by the respondent, and hence they are not conducting the they're not, and hence at present they are not conducting the case. And also paid for fixing the name of the name of the present name of the 3 councils which has been reflected in the cause list. Reflect the cause list. After your brief is already taken back, you have submitted. So thereafter, have you made any communication with that we are withdrawing your name from the Kalatama or thing?
Yes,
Is
yes.
there any communication from your side?
Lordship, we have not communicated. They had come to our chamber and they have taken the brief from us, and the NOC was
The brief is
NO
okay.
NOC was granted by them.
NOC was?
They have given us a NOC that they are taking the brief, an entire file from us, Your Lordship.
Oh, that NOC is with you.
Presently, it's not with me, but I can.
So
It's
this,
with me, Your Lordship.
matter be adjourned, it should be council for this one to punish the NOC which has been submitted by the respondent while taking back the brief, taking the brief from the councils. Let the matter be accordingly listed. We're listing it on 3rd of June. Just punish us, then we'll pass the order for deleting your name.
Lordship,
Lordship.
obliged.
My ladyship, there is an interim order in this.
It must be continued.
Kindly
May I please? Lordship, my lord, item number 1, 2, and 3. My lord, may I therefore taken up on next week? With some difficult.
1, 2, 3.
Yeah, yes, sir. Next week I need to
These are all connected matter out of
Connected.
same FI.
connect with something. Some instructions sheet with
Some instructions.
yes. Maybe next week I need it.
Week 2 we cannot say next week is almost full.
Lordship. Then thereafter, Lordship.
1st of
Except,
June,
no, my lord, except 1st of June, it should be there.
2nd, 3rd we can.
Third,
3rd of June,
third of June.
1, 2, and 3. Part Mr. D. Gauhati submitted that they want take some more instructions from the petitioners and accordingly we will find it. Considering the submission made by Mr. Google, that the matters will be listed on 3rd of June. 1, 2, and 3. In motion.
Lordship, deeply obliged.
Lordship, due concern with other side, Lordship. I beg to mention item number 29, Lordship. Lordship, may the matter adjourn for the day.
So there was a lead petition.
Lord.
Lead petition was pending in fact,
Yes,
criminal lead petition.
Yes.
So you are for the whom? You are for whom?
petitioner.
You are for the petitioner. So have you informed the other side?
Yes, Lordship.
Consent of the other side. And also your good name?
A.R. Mondal on behalf of Yes Islam.
You are
A.R. Mondal.
A.R. Mandal, appearing on behalf of Mr. A.J.S. Islam. Prayer allowed.
Next week, any day.
Next, 1st of June.
Highly obliged.
May it please your lordship, I beg to mention item number 19. CD has not been received, your lordship.
Yes, what is 19?
Ashok Chauhan,
Also,
Secretary Bail, CD.
are they on interim otherwise? Interim was there. So your case already charge sheet has been submitted. Do you want to take any instructions from your senior counsel or otherwise we'll pass the order extending your interim for 15 days so that you can appear before the learned trial court below with a appropriate application for bail. That order may be passed, otherwise if you say for some being, you can keep it. You are appearing from your good name is reflected here in this case?
No.
My lord, I am.
Or you are here? Achha, okay then. So we'll pass the order.
My lord.
You are Mr.
Ahmed.
Huh?
Ahmed.
A. Same order. Yes, CS number is?
Number 148 of the 26, dated 24/2/26.
So that order will be accordingly passed.
I am on interim, my lord.
Yes, we are extending your interim for 15 days.
One more beer, my lord.
15 days will be well.
I'm praying for listing of bail application for withdrawal.
Bail application for?
Withdrawal, your lordship.
Make a mention before court number, I think 8. Court number 8 or before raised.
Your lordship, for item number 8, item numbers 18, 20, and 21, CD is not available.
18.
18, 20, and 21.
These are all connected matters or what?
20 and 21 are connected matters.
In all 3 items?
18, 20, 21.
No, whatever 20 and 21 are the connected matters where they received. Pardon? No, petitioners are different. I'm asking whether any interim was there in both the matters 20 and
Yes, interim was there in both the matters.
CD not received.
CD not received.
Your good name is not reflected here?
Your lordship, I am actually appearing for
T.
Mr.
Laskar.
P.A. Lashkar.
CD. Yes, what happened?
It is from
Samia.
the book of 5th of June.
5-6 interim be continued till next date of listing. And what about 18?
18 also the petition in interim lordship, CD not received.
Here also CD not received.
5th of June, that same day.
CD not received. Should remind that 5th of. Okay, listing it on 5th of June, your interim is continued.
Please, your lord.
Please, your lordship.
With the consent of the petitioner, I beg to mention item number 11. Instruction is awaited in this item, lordship.
Instructions is awaited for you for a response.
I am for the respondent.
Acha.
Just waited and we need 3 weeks time.
Sir, have you filed your affidavit or in
I
opposition?
pay for 3 weeks time to.
Mr. M. Sharma was there.
Yes, I am appearing on behalf of M. Sharma. Lordship, the interim may be extended.
There was interim.
Yes.
You're Mr.
A. Hussain.
A. Hussain. Mr. A. Hussain appearing on behalf of Mr. M. Sharma. Petitioner also heard.
K. Kolita.
K. Kalita appearing for K. Parash.
K. First.
Appearing on behalf of K. Parash, learned CGC. And it is submitted that till the day of receiving instructions from the department concerned and accordingly with 3 weeks time to file their affidavit of which the council for after 3 weeks and 15th of June. 15th of June,
Published.
interim be continued to
May I please, Lordship, I beg to mention item number 23. CD is not available.
CD now 23, no? Were there any cases registered or not? A report was called for. That report we have received here, Lordship.
received.
Yes, Lordship.
But
That's why visit case has been registered. Yes, a case is registered against the petitioner, Lordship. Height Mukalma PS case number 20/2026 under section 126. The case is registered against that. Call for the
then
case.
the matter will reach it. We just wait, let the matter reach, then we'll call.
May I please, my lord? I am praying for adjourned item number 30 for today only, my lord. It may kindly be fixed on 26/5, my lord.
34,
30, my lord, 30.
30.
0, my lord. Manjuli Devi is out of station, my lord. I am praying on behalf of her.
You are appearing for whom?
Lordship petitioner. It may kindly be taken on, my lord, 26.
No, 26 is not at all possible. It will go at best on first week of June, that is on first, second, third of June.
Lordship.
at the
Obliged,
request
Lordship.
by Nare. Matter is existing matter. Pieces.
May I please, Lordship?
Yes.
Okay, this is clear as well, Lordship. My lord, informant sites and petitioner site, my lord, involved in quarrel for a road, Lordships. What the site, my lord, belong to same dynasty, Lordships. And my lord, all the petitioners belong to same family, Lordships. My lord, page 15 is the affair, Lordship. This is vernacular. May I read the affair, Lordship? বিনীত নিবেদন এই যে আজি ইংৰাজী 15/3/2026 তাৰিখে পুৱা প্ৰায় 9 বজাত পদুপুৰী গাঁৱৰ চৰকাৰী PW ৰাস্তাৰ কাম কৰি থকা অৱস্থাত তলত নাম দিয়া প্ৰতিজ্ঞাগণে হাতত দা ডেগাৰ লোহাৰ ৰড বাঁহৰ লাঠি আদি লৈ আমি কৰা কামৰ স্থানত প্ৰৱেশ কৰি কামত বাধা প্ৰদান কৰে। আমি উপ ঠিকাদাৰ হিচাপে প্ৰত্যুত্তৰ কৰাত পদকীয়গণে আমাক পানে মৰাৰ উদ্দেশ্যৰে মোৰ ভাতৃ মতিউৰ ৰহমানক 2 নম্বৰ পদকীয়াই মূৰত ডেগাৰে হাপ মাৰি গুৰুতৰভাৱে জখম কৰে। মোৰ খুৰা চাহা আলী 40 বছৰকো 3 নম্বৰ পদকীয়াই দাৰে মূৰত ঘপিয়াই গুৰুতৰভাৱে জখমপ্ৰাপ্ত কৰে। মই মোৰ ভাতৃ আৰু খুৰাক মাৰপিট কৰা দেখা পাই আগবাঢ়ি গৈ বাধা প্ৰদান কৰাত পদকীয়গণে মোকো লোহাৰ ৰডৰে বাওঁহাতত প্ৰহাৰ কৰি হাতৰ হাড় ভাঙি পেলায়। 1 নম্বৰ পদকীয়াৰ প্ৰৰোচনাত বাকী পদকীয়গণে আমাক আজি এই ঘটনা কৰে। This is the allegation against all the petitioners, Lordship, and women also, my lord, they have implicated, Lordships. My lord, my prayer is that, my lord, CD may be called for and my lord, along with the injury report, lordship. And in the meantime, my lord, I may be protected. And petition number 1 is the, my lord, teacher of a LP school, lordship. And against him, no allegation is there, only instigation is there, my lord. And my lord, allegation, basically, lordship, petition number 2 and 3, lordships. My lord, and others, against the others, lordships, no such allegation, lordship. So, my lord, for a road lordship, this incidents occurred, lordships. And my lord, both the side, my lord, belong to the same dynasty, lordships. So till then, my lord, we may be protected, and my lord, CDR along with injury report may be called for, lordship.
So previous injuries, they are also with attacking by sharp weapons by Dow, dagger, lordship. So
That is the allegation, lordships. That is why I am praying for, my lord, injury report, lordships, medical report, lordships. So, my lord, petition number 1, my lord, is a teacher, my lord. And he is also, my lord, due to this allegation, my lord, he could not go to school, lordships. My lord, kindly protected us, lordship, because and in the affair, it is reflected that for a road, lordships. Yes, this road is belong to the petitioner, lordship. They, my lord, tried to construct a fancy over that road, lordship. When they went to, when dear lordships, some quarrel took place between them, lordships. So, my lord, in village area, this kind of situation happen, lordships. Your lordship knows, lordship. So, my lord, I am praying for medical report and my lord, CD, lordships. And it will be clear, lordship. Till then, we may be protected, lordship, and one woman is there also, lordship.
I prefer only case there because injuries by sharp weapons, previous injuries there also.
Yes, that is the allegation.
Attacking by Dow and dagger also.
That is colored, my lord, to only to book some non-bailable offense, lordships.
Yes, I would be same. That there is, but the effective system of such injury is tested as expected. But the couple or all the petitioners are dated with this. And it will submit them. Submit it and it so serious nature of but the previous also by sharp opposite. There was also a part of the victims. Considering this and considering the statement in the right. This would the opinion if 1, 4, 5, 6, 7, and 8 maybe but it will submit is that however prayer when is not considered stage. CD. Yes, when it can be
3rd of June.
CD. 3rd of June. Your 2 and 3 are not protected, other raised up.
I am deeply obliged.
May I please, Your Lordship? Lordship, 482 bail application, Lordship. Lordship will find the FIR in annexure 5, page number 15 of my petition. It's a long FIR, Lordship. Actually, the informant is a representative of T company. And the basic allegation, for a moment, if Your Lordship peruse, the accused persons, page number 27 of my petition, for a moment, ma'am.
27.
7. these are the names of the accused persons. Accused number 1 is Billwell Solution Limited, India. Second, Rajendra Prasad Agarwal. Third, Nikit Moore. And fourth, Biswajit Datta. Presently, the present petitioner before Lordship is accused number 4, Biswajit Datta. I am not for the other 3 accused persons. And present petitioner, at that time, he was the regional sales manager of Tata Power Solar. And these 3 persons that form accused number 1, 2 and 3 are the authorized representative of that particular firm. The allegation is that the informant company contacted the firm accused 1, 2, and 3 for installation of a solar plant in their tea state for around 73 lakhs rupees or 79 lakhs rupees. And as per the informant's story, that they have paid the entire amount, but the accused persons didn't complete the entire work as per their agreement. So basically, it's a breach of terms of their contractual agreement. And there is nothing short in against my client, my petitioner, present petitioner. There is no allegation against me. For a moment, if your lordship pays
What was he working? He was working for?
regional sales manager for Tata Power. This company, Buildwell, is a channel partner. Their duty is to collect the contractual work or some work, and they have thereafter place a quotation before the party, and thereafter the company directly paid the party directly paid the amount to the company's account. There is no involvement of the present petitioner. Lordship may, if your lordship peruse page number 20, it's a starting FIR starts from page number 20. First paragraph, lordship may skip. The second paragraph is, may I read, lordship? That our company is a registered consumer of Assam Power Distribution Company Limited, APDCL, bearing consumer number so-and-so. According to our requirement of a solar plant, power plant, we had applied through the official APDCL Rodali website on 27/12/2024. For a moment, lordship may see the date of FIR is in the same page, top 7/10/2025. They lost that FIR in the month of October 2025. 7/12/2024, white application number so-and-so for installation of a solar power plant at our factory premises situated at Golaghat, Assam. Next page. That subsequent to the above, we had approached and engaged Buildwell Solution India, a firm acting as EPC contractor and an authorized channel partner of Tata Power Solar upon their commercial proposal for installation of 250 kWp solar power plant at our said Golaghat tea factory premises. The said Buildwell Solution is represented by its proprietor, Rajendra Prasad Agarwal, and authorized representative Nikit Moore, the accused number 2 and 3 in the FIR, my lord. I am accused number 4. That relying upon their claim of being authorized representative of Tata Power Solution and believing that the funds collected by them were being collected on behalf of Tata Power, we proceed to in good faith to place our order. Right, email letter so-and-so, we had duly confirmed our order, and in reply, they directed us to deposit the booking advance amount by 9/12/2024. In pursuant thereof, we made a payment of rupees 6,15,000 as booking advance amount on 9/12/2024 through RTGS by check number so-and-so in favor of the Buildwell. In favor of the Buildwell, not in favor of the company. That subsequently, the said accused person issued quotation reference number so-and-so dated 7/5/2025, quoting a total amount of 73,97,000 for carrying out the said project or installation of so-and-so 250 kilowatt solar plant with breakups as follows. These are the breakups of payment, lordship, how they have to pay this amount against what. Next, lordship, that the said quotation document expressly mentioned inter alia that the prices were inclusive of design, manufacturing, sourcing, testing, supplying, installation, and commissioning, freight and in transit insurance, and further laid down the following payment terms: 20% supply price and INC along with the purchase orders, and the B 80% of supply price. And
Very terms and conditions of.
yes, these are terms and conditions. And perhaps they paid the entire amount. Perhaps accused number 1, 2, 3 are responsible. Lordship, if your lordship turn the page number, next page number 23. They said that thereby, as on 21/6/2025, we had made the entire payment of 73,97,000 to the said accused company, fulfilling 100% of the quoted projected price. However, despite having received of the entire project amount from us, the accused person have till date neither commenced nor executed any work at all for the installation of the said solar plant at our Golaghat tea estate. Furthermore, they are now completely avoiding and not making any fruitful communication with our company or representative despite our repeated follow-ups. If your lordship turn page number 24, only in that particular paragraph, on the first paragraph of page number 24, my name is mentioned. How I am connected, lordship may kindly see. It is also pertinent to mention herein that despite our several attempts to reach out the accused persons, especially Niket Moore, mobile number so-and-so, that is accused number 3, and Biswajit Datta, the accused number 4, mobile number so-and-so, who were the designated points of contact. That means what happened when the channel partner used to place a quotation before a party, as per company rule, they have to mention 2 contact number. One of their firm, that who the channel partner. Second, the regional sales manager, for transparency, my lord. And what they have stated here in that particular paragraph, no meaningful response has been forthcoming from them. Meaningful response. Actually, what happened? They contacted me that we paid this much of amount, but the materials is not yet installed. As a regional sales manager, I have no any administrative power or any such power company delegate to me to take any action against the channel partner. My duty is to escalate the complaint to my higher authority. Accordingly, I did the same. I received a complaint as a regional manager that this particular channel partner is not working as per their agreement. Then I escalated to the higher authority. Except this paragraph, nothing that's all, lordship. I am not involved in any monetary, and in fact, at that time, I'm working as a regional sales manager in Tata Solution, Solar Power. Now I am working in Luminas as a general manager. So after losing of the FIR, company released me also. I give my resignation to work in the other company. If your lordship kindly see. Annexure 6, page number 29. This is the release order from the company. In the second paragraph, the company itself, the HR mentioned that we thank you for services rendered by you to Tata Power Renewable Energy Limited and wish you a success in your future endeavors. So I resigned from in 16 December 2025. FIR laws in April. I am nowhere connected, and my reason of apprehension for filing of the instant petition, lordship, annexure number 4, page number 14. Recently, I received a notice from the IO. I am ready to cooperate with the investigation, my lord. And the difficulty is that whenever a person in the corporate sector, when I resign from my job, I have to give all my user ID and all credential, laptop, everything to the company. I have to deposit to the HR. So at this stage, I am unable to provide any evidence before this honorable court that I escalated the mail to my higher authority and all, because it is with the Tata Power Solution, because now I'm working with Luminas.
Yes.
Yeah, lordship, he is the prisoner is an FIR named accused, lordship. His name is there. So without the appraisal of the case die, what is his role and involvement in this case, lordship? Cannot ascertain at this stage of lordship. And
Lordship, FIR is on dated 17/25, and he has resigned from the post of on 19 November 2025 and accepted on 16 December 25. Lordship. So after the completion of the FIR, he has resigned from the post. So there may be something thoughtful in their nature, Lordship. That's why I pray for case day at this stage. Lordship.
I'm ready to appear before the IO to record my statement also, Lordship. I'm ready to cooperate, but the thing is that the sections are non-bailable. My protection, maybe Lordship may protect me.
So what presenting this it is a fact that he was deterring his duty as regional manager of solar power and solar power. During that period, as per the allegation, the contract has been paid for installation of solar power in the company, and the accused number 1 and 3 are the authorized person from the their company for the sale. He is not aware of financial dealings of between the informant company and the company accused company, and simply discharging the duty as a result. However, the fact that he received a complaint from the informant side in his contact number, and being a regional manager, he has no authority to take any action. He had communicated the complaint with higher authority. Therefore, there is no role in this case. There is no, he played no role in this case, and no role in this case. He already received from the IO on section 35(3) BNSS, and is ready and willing to appear before the IO to record the statement. If some interim protection is next program is some his objection is submitted without further the case diary. His involvement in petition cannot be stated, cannot be said, and he insisted for the case diary. No, the submission or it's supported of some petition. He'll sit on the case diary. Hope you will be under interim protection. Abide by all the terms and conditions of the bill.
Obligation. Mass obligation.
Yes, to submit by
9th of June.
My lord, in this case,
Hmm.
One minute, Lordship. Lordship, the present petitioner before Lordship, this FIR is outcome of the FIR what we filed prior to this FIR before the concerned police station. Our FIR is in Annexer 1, Annexer 2, page number 16, and the FIR against which we appear before this Lordship, before this Honorable Court, is Annexer 3, page number 23. And if your Lordship kindly peruse the page Annexer 2, page number 16. This is the FIR filed by my sister against these two accused persons, Pankaj Nath and Jolly Nath. It's a short FIR, my lord. Vernacular is in page number 16. Lordship may peruse. The accused person, Pankaj Nath, supposed to get admission, my admission in a school, and his informed us that for that we have to pay 20,000 rupees for admission fees and tuition fees and all. And thereafter, we have to sit in the exam, and thereafter we procure a certificate from the authority so that I can go for a higher study. I continued till class 8. I want to pursue my higher study. Thereafter, when we approached him, he produced some documents which are all were fake documents. So we went to his home to return back the money, but he didn't return it and physically assault my brother, that present petitioner. And thereafter, my lord, we went to the Sualkusi police station to lodge an FIR, which was registered as a Sualkusi PS 19 of 2026. And when they came to know that we file a FIR, they went to the police station and lordship page number 23, annexure 3. This is an FIR, small FIR filed by the wife of that particular person, alleging some false and fabricated story against us. They also confined our vehicle also. Subsequently, we filed a Zimma petition and took the custody from the Hazu Judicial Magistrate First Class Hazu. So the thing is that, my lord, on the basis of these allegations, whether custodial detention is necessary, I am ready to appear before the
Where is
IU.
FIR? Present FIR.
Present FIR is page number 23, annexure 3, my lord. So small FIR, lots of mechanical. This is registered as Kualkusi PS 20 of 2020, subsequent to our FIR. Absolutely false allegation, my lord, and we are ready to cooperate, my lord.
It is a price of 22.8, 22.426.
Which one?
Annexure page 23.
Page 22.
And your FIR is,
My FIR is in annexure 2, page number 16.
it's also 22.426.
Same day, same day. I'm not denying that. But after filing of my FIR, when they came to know, they approached the police station and this FIR filed. I'm ready to cooperate and I have to appear before I have to record my statement, my lord. But the question is whether custodial detention is necessary in this against this allegation.
An application significance. It's what plus. And for the FIR lost by them, which is registered as well CPS system 90. The lodging of the FIR an FIR is lost against them with some but a subject that the president the sister initiated lost by a package informant and with the election they take rupees they took rupees 20,000 with an assurance of giving some certificate for the higher study of the present petition. When they came to that fake certificate, they produced some fake certificates. They went to the station and got an informed with some forms in view of this, recording is submitted really and really to extend their cooperation in his cooperation in the further investigation. If he is allowed to submit done is city may be called of the support that interim period has been we to the in okay, will be under interim to receive
5th of June. Same date to me. 9th of June, I don't, same day, or the earlier. 9th of-
9th of
Obliged on, deeply obliged.
May I please, Your Honor? For 82 application, Your Honor, FIR is phase 13 law. May I read?
yes.
Now, I, Moinuddin Sheikh, son of such and such, are residing at Northeast Frontier Gosala Samiti branch, Jalukbari, Gauhati 12 under Jalukbari police station. I am working as a worker at said Gosala along with my family, where around 30 cows are kept. About 2 months ago, two persons, namely Soleiman Ali and Zakir Ali, phone number such and such, reside Borpeta, came to Gosala and sometimes stayed there. On the previous night at around 8 p.m., both of them again came and stayed at the Gosala. Early in the morning, around 4 a.m., I discovered that 19 cows were missing. At the moment, I was very shocked and nervous. From that time till now, I have made my own enquiries and searched for the missing cows, but I have not been able to get any information regarding their whereabouts. I strongly suspect the above mentioned persons are involved in the theft of the cows. Your Honor, owner of the Gosala is Yaqub Ali, and Soleiman Ali and Zakir Ali used to visit those Gosala, Your Honor. And Soleiman Ali bona fidely purchased those cattle from the Yaqub Ali. Your Honor, kindly have page 12, Your Honor. Page 12, second para, Your Honor. Accordingly, the matter was entered by JLB OP ZD Nong such and such and entrusted upon me for causing an inquiry. During the course of inquiry, the petitioner, namely Moinuddin Sheikh, was examined and statement recorded. On examination of facts disclosed by the petitioner, did not cooperate with the matter and petition raising a sense of suspicious over the entire episode. Henceforth, petitioner was thoroughly interrogated, wherein the petitioner finally revealed that on the night 17/3/26, the owner of the Gosala, namely Yaqub Ali, had a feast with his two close acquaintances, namely Soleiman Ali and Zakir Ali, of Pahlaji Borpeta within the Gosala premises. During the course of their sitting, the owner Yaqub Ali called upon the petitioner Moinuddin Sheikh and ordered him to hand over the cows to Soleiman Ali and Zakir Ali as per their requirements. After feast is over in the midnight, thereafter, while they were shifting the cows over a 1109 truck, he fell asleep in the meantime. When he wake up at the next morning at around 4 a.m., he found 19 numbers of cows gone missing from the Gosala, and accordingly, owner Yaqub Ali instructed him to lodge an FIR at Jalukbari OP. Your Honor, I am the friend of the Soleiman Ali, Your Honor, and Soleiman Ali and Yaqub Ali also granted a regular bail, Your Honor. Kindly, Your Honor, protect me and call for the CD, Your Honor. I am ready to cooperate with the investigation authority, Your Honor.
And the letter about the FIR in the page 12, Lordship, here in the written. May I read, Lordship? Under the above facts and circumstances, it is clearly evident that the owner of owner Yakub in close convenience with co-associates, namely Soleiman Ali and Zakir Ali, heads the conspiracy of illegally transporting the cows for the purpose of selling without any lawful order. So there is a conspiracy regarding the transportation of cows, cattle, lordship. So at this stage of lordship, I prefer case only, not for any interim protection because it is serious offense.
Your Honor, Soleiman Ali purchased those kettles from Yakub Ali in bona fide manner, Your
The
Honor.
latter part he did, just to see, under the above facts and circumstances. It is
Yeah.
not a case of purchasing the cattle.
Yes.
It is a case of transporting the cattle.
I am only the friend of the Soleiman Ali, Your Honor, and I'm along with Soleiman Ali. I visited those this Gosala, Your Honor.
CDP call for the CDP.
And Soleiman Ali also granted bail.
Give a
Your Honor.
short date.
29 minutes. 2nd of June then. 2nd of June. 2nd of June.
$28.
38.
Oblige, Your Honor.
Charge sheet subject. This is scan copy. Charge sheet subject. Charge sheet. Scan copy call for I think.
May please lordship, the seed was called for lordship. Today is the lordship 83 days lordship. 83 days behind the bar lordship.
You can appear. Which
The
Approach
lord-
the trial court.
No lordship, the call for the scan copy lordship. And the lordship, the page,
scan copy, you cannot say scan copy. What the number, the where code is pending.
the lo-
You approach the, you're behind the bar, so what is the issue? You are
Well-
still behind the bar. If there is any rejection, come this court
and
before.
lordship, the page 20 lordship.
No,
The-
no, we are not saying. You are
The
saying
lordship,
that-
the section 36 is not followed.
No,
Lordship.
but it is charge sheeted now. It is charge sheeted now. So you can take those plea. No,
Approach the
if you
trial
are-
court. Lordship. Thereafter,
because the
lordship.
case is charge sheeted.
The
Can
lordship,
approach those plea also can be taken before the
Yes.
court. 83 days custody can also be taken up. As it is charged, we don't want.
Thereafter, he may come.
And if you want insist to call for a case, scan copy, it will take 1 month.
Lordship.
After 1 month only will be, not prior to that. So better to approach it. Yes, what is this?
Right CS number 188/26.
One?
188
Ah.
oblique 26 dated 15/5/2026.
Heard Mr. N. Ahmed did done it counsel for the petition of Mr. D.P. Goswami did done it additional D.P. said this was fixed before engaged diary, but it is submitted by Mr. Goswami that case has already been transited at CS number Swenson. It is Swenson. Next, in that context, Mr. Ahmed did done it counsel the petitioner submitted as petitioner that he is behind the bar since last 3 days. And considering his period of detention, he may be under. Next, as case has already been tried against the present petition, he is directed to appear before the
lordship call for the CD scan copy lordship. The in trial court the earlier rejected lordship.
Huh?
Earlier rejected lordship, the call for the
You
scan
place
copy
this,
lordship.
these things before the court now.
The lordship is scan copy is lordship.
Where is the case is pending before which court now? Which court?
In the session judge lordship.
Session judge? You know,
That's Polo, Sunit Polo.
you have received the case, summon.
No, lordship. He's the behind the bar lordship.
First approach the trial court and later if trial court denies, then he can approach the Honorable High Court again.
What is the bar? because he is inside the jail only.
Lordship.
It's not outside, isn't it? I think better to approach the trial court because there is everything is there, and we don't know where is the copy is still lying. So you will another say in 1 month you have to be behind the bar. That we are not giving you a very short date now. We cannot also. The scan copy is to be called for. Okay, then if you insist, scan copy be called for. Okay, the control 15th of June. Along with the instruction.
Lordship.
CD already received.
Lordship, the FIR is page number 19, Lordship. Main allegation is that, Lordship, the petition, a huge quantity of fake Indian currency notes was recovered from a vehicle which was parked in front of the house of the petitioner. Lordship. It was recovered at about 11 p.m. of the night, Lordship. At that time, the petitioner was sleeping inside his house, Lordship, and he has no next.
Fake currencies were recovered.
Fake currency were recovered from a vehicle which was parked outside the house of the petitioner.
From vehicle.
Vehicle. Lordship, he is in custody from the 40 days, Lordship, and he was remanded to police custody for 2 days, Lordship. He was
So
fully
he is in
interrogated
custody
by
for
the
40
police.
days.
40 days, Lord. Fully interrogated by the police, Lordship, during remand period, Lord. Nothing was recovered except some self-incriminating materials, Lord, as per the information of the petitioner.
Nothing recovered except some
Self-incriminating materials, Lord.
self-incriminating.
As
I
per
mean, it is
the, as per the
incriminating him.
information of the petition,
Incriminating him only.
that will be revealed in the city, Lord.
So if those is self-incriminating, that is then to it is highly.
That will the city, Lord.
And you are saying that those the materials which have been recovered are self-incriminating. And why you are saying that self-incriminating? What is the meaning? Or why you have said? Yes, anyway.
Yes,
So
Lordship,
you are in custody for 40 days.
40 days.
Lordship, page number 20.
20.
20. This is the forwarding, Lordship. Lordship, facts of the case, Lordship will find. Brief of the case is that complainant so-and-so on 10/4/26 at about 9:50 p.m. reliable information was received that one person named is Abdul Ali. He is the present petitioner. Son of Raham Ali. Lordship, this is important. Raham Ali, son of Raham Ali. Handed over fake Indian currency note worth 2 lakhs to his sister-in-law Sajida Begum, so-and-so, at around 7 p.m. on 10/4/26. The FICN has been kept in an e-rickshaw, TomTom, which was standing in the house of Sabdul Ali. He is the owner of the TomTom. They are planning to deliver the said FICN tonight to someone. It is to be mentioned that Sabdul Ali, Sakibul Islam, and so are habitual so-and-so, Lordship. And after that, Lordship, next paragraph, Lordship will find the fake currency notes were seized. Altogether, 1,17,500. And Lordship, this is the case. And thereafter, Lordship, this petitioner were arrested and the other persons are absconding as of date. So, Lordship, investigation is still going on. And here, Lordship, the attributed sections are 178, 79, and 180. That is, Lordship, 179 is punishment up to life, Lordship. So 90 days is the mandatory period. And Lordship, in their petition at paragraph number 7, Lordship will kindly come. That is their plea, Lordship. The vehicle is not his. Lordship will kindly see paragraph number 7. Lordship has found it. Lordship, yes. That the petitioner states that he is cultivator by occupation, he is neither owner nor driver of the alleged vehicle. As per his information, the owner of the alleged vehicle is Sukur Ali and was being driven by one Abdul Rahman. Both of them are known to him as their neighbors. Now, Lordship, in the court below, one Zimma petition was filed by Sukur Ali, Lordship. And that Sukur Ali is son of Roham Ali. So that Sukur Ali is his brother, Lordship.
And he is son of Roman.
Yes. Petitioner is the son of Roham Ali. So at this stage, Lordship, investigation is still going on. The source and the person intended to whom it was to be given, Lordship, there it is still investigated. So at this stage, Lordship, I am praying for further custodial interrogation of the petitioner, Lordship.
Lordship, in regards Lordship ownership, I have annexed a report, Lordship, in page number 22, Lordship, which is downloaded from M Poribohon app, Lordship, which showed that the owner is Sukur Ali, Lordship. As per my information, Lordship, Sukur Ali is not his own brother, Lordship.
So your father seems to be same.
The same Roham Ali,
You don't
maybe,
know,
Lordship,
maybe.
maybe another, Lordship.
Baby, but it seems
As per
that
my
your
information,
father,
Lordship, he is not his own brother, Lordship.
own brother.
Not own brother.
The father's name is same, Lordship. They are also resident of the same village.
Father's name is same.
Maybe some another Roham Ali may be there.
That is
But
very
as per my information, Lordship, he is not his own brother, Lord.
In any case, Lordship, now, Lordship, this is a very serious offense, Lordship. This is a crime against the nation, Lordship. Fake currency, Lordship. So I'm praying, Lordship, that it may be dismissed at this stage.
Lordship, as the Lordship, the recovery was not from his active or conscious possession, Lordship. It was recovered from a vehicle which was outside the house of the petitioner at 11 p.m., Lordship, at night during night hours, Lordship. When he was slept inside his house, Lordship. At that moment, it cannot be presumed there. Lordship. Already he undergone a considerable period, Lordship, of 40 days, Lordship.
You have not provided with
He is
the-
ready to appear each and every day, Lordship.
No,
Since the
regarding
co-accused is
co-accused-
not apprehended yet, Lordship.
You have not provided, you are not cooperate with the investigation regarding the other co-accused person. Because they are still
He's
absconding.
absconding, Lordship.
Yes, absconding. That's what I'm saying.
I'm inside the bar, Lordship. I have no connection with the Lordship, the co-accused. And this is kindly made, Lordship.
You are Mr.
R. Hawk, Lordship.
R.
R. Hawk.
R. R. Mr. R. Also R. Mr. Submitted by Mr. President. He did not there's no connection with the it's the fact that some big currencies were took from a vehicle which was parked from their house and it was and the big currency notes were recovered and seized at 11 p.m. when the petitioner was sleeping in his own house. He was not aware about the big currencies kept safe. He further submitted that the accused petitioner is in custody since last 40 days, including 3 days police removal hence, and the IF was sufficient opportunity to interrogate him, giving him in custody. He further submitted that he is willing and interested to cooperate with the client in further investigation case if he is granted with privilege. There was no recovery from the concession in investigation. And he is not even the owner of the say big which was parked in the impound. Next, Mr. Sharma did not is submitted. There are sufficient remaining details in this petition and petitioner and he is still under investigation. Further submitted that from the forwarding report of the present petitioner and the statement made in the last 7 of the petitioner also reveals that the owner of the vehicle, the owner of the vehicle, Mansukul Ali, is the own brother of the present petition. Thus, own brother of the petition, but submitted that the other 2 accused persons are still accounting and they are yet to be apprehended by investigators. Mr. Sharma further stated that case is registered in section 179, 180 of BNS, wherein 170 section 179 is a offense which punishable with life. He further submitted that the case is very serious in nature, wherein one has big currencies note were recovered from the position of the president. And this is an offense against his nation. Instruction accordingly raised and population submitted that if not it is to allow the petitioner own way. Submitted that the said is not his own brother and he may be son of another Rahman Ali and he is not the brother of the petitioner. Considering the submission made by both sides, matters is that recovery of the currency notes from the original and other aspects of the case, seen that part of custodial interrogation may be necessary to unearth some and also to apprehend the other co-accused persons who are still absconding. Case is still at the stage of investigation and further custodial interrogation may be necessary for the purpose.
So may I submit on thing, Lordship?
The petition, it's also is there. Yes.
Lordship, since the co-accused yet to be arrested, Lordship, and he is absconding, the further investigation may not be completed within likelihood in a short period, Lordship.
Let us see.
40 days
Your
may be
petition stands.
considered.
Okay. Your petition stands rejected.
Yes.
It's already written.
70. CD not received, Lordship.
CD not received. You are in custody since when?
Lordship and 1/5, Lordship.
First,
For a moment, Lordship,
First of-
one,
No. We are
19
not
days,
going to
Lordship.
hear the matter. Since when you are in custody?
1/5,
That's what
Lordship.
Huh?
1/5, 19 days,
1/5.
Lordship.
90
And-
days offense.
Lordship, and
Yes.
just for a moment, the FIR, Lordship, and only 2 numbers of goats, Lordship, and court red-handed, already been handed over to the owner of the goat, Lordship. So for a moment, Lordship, the FIR, Lordship.
No. We are not going to hear the matter. We have called for a case diary. That's all.
Otherwise, Lordship, the 3032, Lordship, for first offense, Lordship, only, which may be extended to 3 years, Lordship, punishment.
Short.
Okay.
Thank you.
Sorted.
Lordship, before Eid, Lordship, and 27 is Eid, Lordship.
26.
Lordship, deeply obliged, obliged,
CD should be
deeply obliged. 23.
What is the position of 23?
23, Lordship, report was called for. Report has been received on the earlier date also. Case has been registered.
Okay,
And thereafter, Lordship, CD was called for, but CD has not been received.
they are on interim now.
Yes,
Yes,
Case has already been registered.
yes.
Hard MS,
A point.
hard MS A paying, Ilane cost. Be sure Ilane PPA we have to. It is submitted by Mr. Sharma, the city with divisions. Issue remand. Yes. But
First of
first of 1/6
1/6. Obliged, Lordship.
interim be continued.
CD received, Lordship.
Lordship, I'm praying for a short pass over.
Can be.
25.
CD received, Lordship.
Yes, your the affidavit. Your we have received your
Well, we have filed affidavit and post title, Lordship. Perhaps post title has not been taken with the record. We have filed affidavit and step has also been taken for regarding service of notice to the respondent number 2. Yes, for last order, Lordship.
registered. So now you have implicated one header Ali. Okay, Ali header. No, who is the respondent now?
Respondent informant is the respondent number 2.
That's what Ali Haider is the respondent number 2.
Already we have submitted the post amended post title, but that is not updated perhaps till now, Lordship. Today, Lordship, it will be updated. We have filed before the filing section. My lord, already step has already been.
Now, who is the respondent number 2? Ali Haider.
Yes, Ali Haider.
So you have already taken steps.
Yes, yesterday, Lordship, we have taken. So let the matter be taken up in the next week, Lordship. I think service report to that effect may, Lordship,
Will come.
act for, Lordship. The CD has come.
No,
But your report on steps is not in the office.
Yes, but I have the copy. Yesterday, Lordship, we have taken. Because last listed on Friday. Yesterday, we have got that time only, Lordship.
Mr. M. Khan, Ilanet Cost. Mr. B. Sharma. Ilanet, this will be every on. It is submitted by Mr. Khan at the person that's ordered. They have already corrected the post type and the name of the informant is being inserted as respondent. 12. He further submitted in the pursuit of the last order, he also taken state for the respondent number. However, there is no stone to that figure. In that context, Mr. Khan submitted yesterday to the state of responsibility and on our in view of this, raised is to verify the status of the respondent number as to whether the steps have been taken. In the same time, let the service be awaited till next day. If steps have already been. Next people, from where it has to come?
Lordship, there was a
The CD has already come.
no. Last day CD was there, Lordship, and Lordship directed us to update the CD. But because it's from Silchar, Lordship, it has not been updated. Friday it was listed. So let it be on 4th of June, Lordship. In the meantime, if CD can be updated, we'll update the CD.
Now you have, they have already took back the case diary?
No. CD is still lying here, Lordship.
Or he has to come from
Yes,
Silchar?
yes, that is right. Lordship.
Our statement has already been recorded.
That CD is still lying before the court, so it was directed to the IO to take back the case diary for application. In view of this, the IO is thereby directed to take necessary steps in taking back the case diary for application and to furnish the same on next day. Mr. Khan, better to list on 4th of June or 5th
Yes.
of June. Okay. We're listing it on 4th of June, hopefully it may reach.
Lordship.
Can you just communicate with the IO
Yes.
so that it can be
Yes,
returned back?
Lordship.
There is an interim order.
Interim but next.
Published.
CD received, Lordship.
Made please, your lordship. The 430 is the anticipatory bail application, my lord. There are 5 petitioners, all are from the same family. 7 petitioners, all are from the same family, my lord. Your lordship will find the annexure 1 is page 9 is the FIR, my lord. Your lordship straightway goes to my lord. Page 15 is the vernacular, my lord.
Yes.
That was laws on my lord. 24, my lord. And 25th, my lord, was the marriage date of the petitioner number was just to prevent the marriage, my lord. This, my lord, FI was lost. Even in a plain reading of the FI, your lordship, my lord, is a very crystal clear, my lord. It is a concordant story, my lord. I'll read the vernacular, page 15, my lord, your lordship, kindly see. মহাশয় সন্মান সহকাৰে আপোনাক জনাও যে প্ৰায় 1 বছৰ পূৰ্বৰ পৰাই 1 নং আছামী পদকীয়া জনী স্বামীৰ ঘৰৰ সংসাৰ নষ্ট কৰি আহি মোৰ আৰু সৰু ভাইটি জেহুল ইছলামৰ 3 লগত বিয়া বহাৰ এক প্ৰলোভনেৰে নানা কায়দা কৌশল কৰি ভয় ভীতি দেখুৱাই 2 লাখ টকা দাবী কৰে যদিও মোৰ ভাইটিয়ে ভয়তে 1 লাখ টকা দিবলৈ বাধ্য হয় আৰু বাকি 1 লাখ টকাৰ কাৰণে নানা প্ৰলোভন উক্ত টকাৰ কাৰণে হেঁচা প্ৰয়োগ কৰে আৰু উক্ত টকা দিব নোৱাৰাত মোৰ ভাইটিক বিয়াৰ প্ৰস্তাৱ দিলেও যদিও প্ৰস্তাৱ অমান্য কৰা 1 নং পদকীয়াজনী বাকী পদকীয়া লগত লৈ যোৱাকালি 23/3/2026 তাৰিখে সন্ধিয়া অনুমান 9:30 মান বজাত কাজাকটা 4 নং খেৰৰ গাঁৱৰ বসবাস ৰামজান আলী ঘৰৰ ওচৰত থকা খাপ পাতি বহি থাকে আৰু ঠিক সেই সময়তে মোৰ ভাইটি বজাৰৰ পৰা ঘৰলৈ আহি থকাত পদকীয়াগণে আগচি ধৰি লাঠিৰে কোবাই শাৰীৰিক বিভিন্ন ঠাইত গুৰুতৰভাৱে জখম কৰে আৰু বাওঁ হাতখন ভাঙি যায় আৰু লগতে থকা 30,000 টকা মোবাইল ATM ডেবিট RC পেন কাৰ্ড আধাৰ কাৰ্ড ভোটাৰ ID দোকানৰ চাবি মটৰচাইকেলৰ চাবি ৰাখি মোৰ ভাইটিক খালি খেতি পেলাই থৈ পদকীয়াগণে পলাই যাবলৈ যায় আৰু মোৰ ভাইটি
চিঞৰে বাখৰ কৰাত স্থানীয় ৰাইজে ঘটনাস্থলী আহি মোৰ ভাইটিক অধিক সংকটজনক অৱস্থাত দেখি আদালত তৎক্ষণাত বিলাসীৰ পৰা হস্পিটেল লৈ পঠাই দিয়ে আৰু ভাইটিক অৱস্থা অধিক সংকট দেখা পাই উন্নত চিকিৎসাৰ বাবে ধুবুৰী মেডিকেল কলেজলৈ প্ৰেৰণ কৰে আৰু তাৰ পাছতে আছামীগণক গুৰুত্ব দেখি আঘাত চিকিৎসাৰ বাবে গুৱাহাটী মেডিকেল কলেজলৈ প্ৰেৰণ কৰে আৰু মোৰ ভাইটি বৰ্তমান মৃত্যুৰ লগত যুঁজি আছে গতিকে মহোদয়ক দয়া কৰি উক্ত সঞ্চয় so that was the FIR my lord even your lordship kindly see my lord it's a absolutely concocus theory my lord just before my lord on 25th my marriage was fixed my lord and my lord that they just to prevent my marriage because the brother of the my lord complainant he was interested to marry me my lord that was the whole story my lord my marriage was fixed with another people my lord on 25th just before 2 days ahead my lord this is my lord this FIR was lost my lord so entire family name was there my lord 7 member of the same family my lord so that now your lordship already my lord case that was called for and my lord very important is my lord injury report, my lord. And your lordship kindly see the line that he was my lord first he was admitted in the hospital, my lord. That is Bilasipara, then Dhuburi, then Gauhati Medical College. All the medical report of the three college is also there, my lord. Your lordship kindly see that definitely it will be in the case diary, my lord. And petitioner number 5, my lord. He is a school teacher, my lord. Petitioner number 4, my lord. He is a graduate school teacher, my lord. And all the members of the same family are here, my lord. And one objection was filed. I am very surprising. And objection was filed. And my lord, there is a report of the Dhuburi Medical College without any signature. And my lord, very interestingly, my lord, page 34. That is one X-ray report was submitted. But that is from the Kokrajhar Medical College.
You have filed your objection. No, you have filed your objection.
Yes, ma'am. This is
Page 34, you are saying.
Yes, page 34, my lord. Page 34, that is a my lord, that is from my lord, that was X-ray, that was photograph shown, my lord, that was done on 10/4/2026, my lord. But occurrence took place 23 as alleged occurrence, my lord.
Still, sorry, your affidavit, the objection affidavit is not here. When you have filed?
yesterday morning, ma'am.
Yesterday morning.
I have the receipt with me.
Pardon?
I have the receipt with me, ma'am.
Yeah, received the copy, no issue.
Kali-
We are not, it's not there.
What my lord can.
No, my lord, your lordship kindly, I am not on interim. Your lordship kindly see, my lord, other documents is here also. Because our plea is that there is no such an incident was happened, my lord. আমি can pay the bill.
So this CD has the medical report. Because
It's okay, now, their objection is
yes,
not. We can call for it. At 2 p.m. will be.
2 p.m. my lord, my one matter was fixed for hearing. Tomorrow, my lord.
Tomorrow, day after, any day.
But I am not in
We
interim.
are
That's
not
why,
on
my lord, you have
interim, that
problem.
is a
Entire
body.
family, my lord. Because I have also filed one reply, my lord. That is Aishan. Aishan.
Senior petition is a meeting, my lord. Not to-
At 2, you have some problem, na?
Yet too, I have one matter fixing, my lord, court number 13, my lord.
Or Then tomorrow we'll got the
File.
supplementaries. But Mr. Get assisted by, yes, you are Mr. J. Islam, Mr. P. Sharma, PF Columbia, and Mr. A. S. Tapata, the learned counsel appearing for the informant. Submitted that the informant has already filed a petition that not has been tagged along with the record. Registry hereby directed take the objection with the case record. And please the matter on tomorrow, that is the Monday. Please that. Okay, we're listing it tomorrow.
Yeah, keep it up.
CD, CDBD. We have received the CD, we'll retain.
Lordship, a report was called for.
Hmm.
If any case has been registered, no case has been registered, Lordship.
No case.
No case.
You are in 28.
Yes, Lordship.
28. Yeah. No case been registered against you. From which police station?
Borpeta,
Borpeta under
under
Borpeta-
Koyagasi outpost, Lordship. Under Borpeta here.
Under Koyakusi outpost. Koyakusi.
Koyagasi outpost, Lordship. Under Borpeta here.
no, under Borpeta PS. This is a outpost, Lordship.
Yes. You are Mr.
Islam, Lordship.
I. Staff. Third Mr. I. Staff. And it will be every submitted by Mr. Sharma. Report received from Koyakuchi in the Borpeta case. And no case has been raised against the presentation. Till date. Let the report be tagged along with its as no case has been registered against the presentation under in Koyakuchi outpost under Borpeta case. The present secretary will for the post. However, the petitioner may approach the appropriate forum in the event of registering any case. The above. You can approach the appropriate forum if any case is registered, but till then.
High level.
May I please, your Lordship? Lordship, this case may be fixed with this case, my lord. And Lordship, here, I have underlined this case is also fixed today, but not listed. I have underlined that order. Your Lordship has passed the
I
order.
have gone through the CDA, Lordship. I can dispose of
Just
this.
a minute, just a minute, just.
Okay,
Both the cases are in the same status and arising out of same effort, two separate petitions filed. And
No, we have received the case diary here.
Lordship. That is there, Lordship.
Scan.
Scan. I have seen, Lordship.
If we say that both the case, then it will be listed in the month of June only. We are not going to fix it.
it's okay, my lord, because both the cases are same and same order may be passed along with this case.
He is saying that it can be disposed of. If he's saying that it cannot be disposed of, then okay. Hard Mr. G. So what it done it? Hard Mr. Yes, what it done it? Will to put that. Yes, what it done it? It's an
And you will.
Scan copy of the TCR has already been received. However, it is submitted by Mr. Sokha that the matter may be
Otherwise, Lordship, she was in interim, Lordship. This petitioner was in interim. She appeared and she was allowed to go on bail.
Then everything is there.
And subsequently,
Why do you?
I don't know also why she, and she has
Okay,
submitted.
I have no
I am,
problem.
I am submitting in his favor.
Ah,
Why this?
Yes,
you
yes.
appeared, your bail is granted, then what is your problem?
Lordship, I have no problem, only one problem, because
Ah.
both are same cases, both are arising out of same. Now, both are in interim, both the cases. And Lordship, if I thought that both the cases may be disposed of together.
I'm not going to dispose of together. It will be in my month of June only. Let the present case may be disposed of.
All right, all right.
What
Yes,
is the harm?
yes, yes, yes.
So there is the order. No? Order.
That order I have not found in interim.
Yes, I was on.
Not on interim.
I was on interim, Lordship.
This order is here. They were allowed to go on bail, you're saying?
No, because her note, there is a note, Lordship, that in the CS also, Lordship, it is written. She was her statement is recorded and she was allowed to go on bail. There in CS, Lordship, search it, Lordship, and even her statement is also recorded, Lordship.
I have fully cooperated, statement recorded,
She had
Lordship.
got the
I
interim
appeared.
protection initially. Subsequently, she in the meantime, subsequently she has submitted. That is why this case in the meantime,
Because it is called for, the second copy was called for because it was session
The
trial.
question is that earlier she was on interim. And
that interim order I have not found. I have not also not got to. I have not gone through the this our court's record. Ever record?
Yes, yes, I am on interim, Lordship.
Thank you, Vijay.
what exactly?
Only problem was that this is sessions triable case. If I appear, bail may not be granted. That's why LCR was called for.
7/4/26 order, Lordship. In our petition also it is written.
Finding you're something that this one statement is there.
Lordship. That I have flag marking also, Lordship.
The charge sheet you have flag mark.
Search it not, Lordship.
Oh,
His
that
her
probably
statement was there in TCL, Lordship. That probably the pink color flag.
Lordship, I want to say one thing. There is a order by your Lordship, and this order has been completely neglected by the registry. It is fixed on 19 today, 19.5, but they are.
Many cases what to do. On your request, we are listing it.
May kindly go.
There are many cases. It's not a question of negligence. There are many cases to be listed. How it will be listed? 60-70 matters are already been. Problem is there with registry also.
That pink color flag is, Lordship, her statement, and green color in CS, Lordship. And green color flag, Lordship. It is a C has not been shown as external, Lordship.
Her name is Rukia.
Rukia Khatun, alias Rukia Ahmed. The photo can be thrown. My photo. My photo can be
Rukia.
This is she is an interim lordship. This is the order. Lordship.
No, that is there. No, you're saying that her statement is recorded. Where is she shown as an absconder in the case there? No. Number two. Yes, number two. Like yo, Rukia কোনটা?
He is not shown as absconder because that is that line is DL lordship in the CS that she was appeared and her statement is recorded, and he was allowed to go with. In green color flag lordship that is that line is there.
Rukia নামটা আছে নি? দেখাতো না।
Port. Rukia take down port আছে। Green color flag.
Yeah. Okay, we'll take up the better. Just show us the yeah. You're not finding it.
Really.
Yep. Local, we have not seen Rukia. Whether she has not been charge seated or what? It's not, Rukia is not here. Just show us. এটা এনেকুৱা ৰঙা এটা মাৰি দিওঁ। ৰঙা মাৰি দিওঁ।
কি হয়?
So that is the status. Mr. G, item number 40. Add Mr. G Somati Lanet. Is of what Lanet additional VP everyone. This is an application of section. That's cases a reports that case has already been charge secured and the scan copy of the decision along with the case that was called for the which is subject that during the Bennett petition she was on interim, she was under interim protection and accordingly appeared and her statement was recorded that she cooperated that from the charge sheet as well as from the is that petitioner appeared and the statement was recorded prior to being filed. In the charge sheet also she was not shown that it is mentioned that it was not unveiled by the and was unveiled. This aspect and the cooperation extended by the petition This petition is court is of that the in repair petitioner. Dated 7/4/26 can be made absolute with a direction to the petitioner appear before the learned trial with a regular application for bail which may be considered inactive. So we made your bail absolute with a direction to appear before the learned trial court bill for a regular bail application.
Lordship, it is a direction, but the case is pending as before SDJMM. And Lordship,
Now,
there
so
has
Honor,
no.
I can understand. What I am saying that your bail we have already made absolute. So there is a formality we cannot give you a regular bail. Cannot give you regular bail. For regular bail, you have to approach. What? Approach before the landed trial court bill as
Obliged, deeply obliged,
bail is already considered.
deeply obliged.
Finding I have item number 23. Made, please, your lordship.
Yes.
As per the last direction, lordship, I have again appeared before the IO and gave my fresh statement. So for source of loan, as on the last date, lordship has inquired about, I want to place some just received some copy on the scan on mobile scanner, lordship. On that day, particularly on 23/8, the accused persons get a account opened in my name at Tezpur Yes Bank, obtained some loan. Then they brought me to the Dispur, took my signatures, take all the money away within instantly. After depositing of the loan, they have taken away all the money away in their account. And to that aspect, I have lodged an FIR at Dispur PS, but that was somehow mostly not registered. On that day, police also took me on 22. Police also took me to Dispur Polyclinic. They have physically assaulted the accused persons and their FIR named accused person. Physically assaulted me. I was medically checked up by police. And due to non-registration on recently, I have again returned to the police commissioner. Lordship, may I place some documents, Lordship? Just the party was supposed to come today, but he could not come due to his illness. I am a victim of this case, Lordship, practically. Now I am facing the loan recovery process at Tezpur Yes Bank. मी इथे थोडीशी असलं नाही ना नवीन स्टेटमेंट
So anyway, 20 lakhs was credited.
29 lakhs. So in my account, loan was credited from Yes Bank Tezpur branch and siphoned away by these accused with the bank officials of that bank, particular one staff. That is on 22/8 loss. I was brought to Gauhati. I was physically assaulted on that day. A medical certificate I have enclosed here.
So how from Yes Bank 20 lakhs were credited to their account?
Loan account loss. They have managed the staff. They have get one loan account by manipulating my documents, taking my documents, all Aadhaar card, etc., my business documents. They have allured me that yes, they will obtain a loan from me. But once the loan deposited, they have taken away the money.
So as per your case,
Lordship.
the other accused person
Yes.
procured a loan on your behalf by using your credentials.
By inducing me, I have signed my papers, not on my behalf. I have signed the papers.
And
They have
when the
assured me
bank-
that yes,
when
a
the
loan will be
account was credited to your account.
And immediately within few minutes, they got it siphoned away. Get it transferred to the accounts of Firdaus Ali.
Yes, Lordship has already seen the FIR. It's a case of cyber fraud, Lordship, whereby Lordship loans are taken in name of different persons by using their identities. And Lordship, all these transactions are done. Now, Lordship, this is one such account of the present petitioner. Lordship has already seen that 29 lakhs was deposited in his account, was transferred in his account. And thereby, Lordship, after that, in a few minutes,
Transferred in his account.
yes. And thereafter, Lordship, from 29 lakhs, it was transmitted to different accounts, Lordship. One of the accused is Firdaus Alam. And there are other persons also, Lordship. And this Firdaus Alam, Lordship, he was arrested. And in his account, Lordship, interestingly, around there is a transaction of around 3 crores, 3 crores 2 lakhs in the account of Firdaus. And from his account also, Lordship, different payments were made to different accounts. So, Lordship, this is a clear case of online fraud because, Lordship, the plea that they have taken, Lordship, bank officials are involved, unknown persons are involved. Is that feasible, Lordship? Absolutely not. Lordship, this is a case of cyber fraud, and the investigating officer is trying his best to trace out the accounts, the level of.
From the account of Firdaus,
Yes.
it was transmitted to other accounts.
Yes, one of such account was Firdaus Alam's bank account. In his account, Lordship, in Firdaus Alam's account, there is a transaction of 3 crores, Lordship, upwards of 3 crores, 3 crores 3 crores 2 lakhs 74,000. And after that, Lordship, from his account also, Lordship, there are multiple accounts from where the amount was transferred. And Lordship will see the level of investigation that is required, Lordship. There are hundreds of accounts that are need to be ascertained, Lordship. Person needs to be custodially interrogated, Lordship, because otherwise, Lordship, the link is never going to come out. And Lordship, the explanation that he has given before the IO in his statement is, Lordship, to state the least, Lordship, it's laughable, Lordship. He does not know anything, Lordship, how this money has come into his account, how it has gone from his account. He has stated that it was transferred from my account. I do not know how it went out from his account. Is this the explanation, Lordship? And Lordship, the person who was arrested, Firdaus Alam, if Lordship kindly goes to his statement, he has narrated the entire facts regarding the involvement of the present petitioner and how it was done, all this amount. a very huge racket, Lordship. Investigation is still going on, and he's not cooperating, Lordship, because these statements, Lordship, are not at all possible, Lordship. If Lordship permits me, I can place the case diary. I have flag marked
Not
the relevant.
cooperating is not, Lordship, I am appeared twice, Lordship, before the IO. I have given new document, Lordship. One medical certificate, one FIR lodged before this food police on 22/8.
Which is not registered.
I am the victim of this crime, Lord.
No. He has received commission, Lordship.
But-
He is receiving commission, Lordship, for transferring this account. Your Lordship, Fidos alone, from his account, around 3 crores transaction was done. He has received commission of 4 lakhs. That Fidos alone. So that is the level of, Lordship, I will, some money is into my account, I will transfer to these 2 accounts. I will receive some commission, they will receive some commission, then they will transfer this account money to another account. That is the whole operation. Now, Lordship, to trace out from where I have been receiving this amount, that needs to be investigated, and police are doing that, Lordship. That is the submission, Lordship. So, Lordship, without custodial interrogation, Lordship is well aware, Lordship, this type of offences will never come out, Lordship, because this is interstate, Lordship. That is my submission, Lordship. If Lordship requires, I will. Yes, yes.
Hard Mr. Escape. And also hard. And also hard Mr. Bishop. The application will be a big about this. It's an application section Swenson. CDDC submitted by Mr. This petitioner is no way connected to and is set friend, rather it is on him very around 20 lakhs been cycle of province loan account. He submitted that the other co-accused person have assured him for a loan, and on good faith only he put his signature in some of the documents, and the loan was accordingly deposited in his account. But soon after the said amount in his loan account, immediately was siphoned off by the co-accused persons and co-accused persons. Coming to know about the same, immediately comes the but that has not been registered and registered. As the FR was not registered, he made another complaint for the SP concern.
SP concerned, SP, Police Commissioner Dispur, Gauhati Law.
Dispur, and the said complaint is still pending for the concern. For the concern. Mr. Porter submitted that he also extended his cooperation in the investigation of this case, and as per direction of this court, he already appeared twice before the investigating officer for him and extended his cooperation. However, the petitioner is still ready and willing to cooperate. He is granted with the privilege of the arrest. Mr. Sharma and submitted that it's a cyber cyber crime where one huge bracket is involved in this office. He submitted that around 20 lakhs, rupees of 20 lakhs was credited in the account of Firdaus Ali. From the materials available, it's that it reveals that more than 3 crores 2 lakhs has already been deposited in the account of say co-accused Firdaus Ali, and from his account was transmitted to various accounts in the entire state, and they upload to, and for the transmission of those accounts, the co-accused was also Ali was also got commission. He further submitted the petitioner is also involved in the present case where the different accounts where there was transaction and transmission of the money in the different accounts from the account to the petitioner. For this, he also received, and for this he also received amount of commission for the same. So Mr. Sharma further submitted that the case is still under investigation, and IO is trying his best to know the source from where the money was deposited, the various accounts of the accused persons. And Mr. Sharma accordingly submitted to know the entire facts to know the source of the deposition, as well as to unearth some more facts of the case behind the huge record of the record wherein a huge record of cybercrime. The custodial interrogation is very much essential. Post. Mr. Sharma further submitted that the statement made by the accused petitioner before the I is not at all believable, but he simply deposed that he is not aware about the source from where the money was deposited or it was transmitted to various accounts. Thus, he is not also fully extended his cooperation in the Mr. Sharma accordingly raised agreement objections and submitted that it is not all of the case to allow the accused petitioner to grant privilege of previous bail to the present petitioner. Okay, I have recorded your submission. We'll pass the order after perusal.
Lordship, obliged, Lordship.
May I please, Your Lordship. Matter relating to NI Act, my lord, the petitioner is convicted, my lord. He is ready to pay. During appeal period, he paid 1 lakh, and today I have given 50,000 to my colleagues, my lord, out of 5 lakhs. The sometime he seeks some time to deposit the entire amount, and they have talked each other.
My lord, the remaining amount means 3.5. He wanted to pay by 8 June.
June
So
second.
the matter may be fixed on 8th of June.
Not
On
next.
that day, he will
It will
pay
be
the
next.
the next the remaining amount in the court.
Not on 8th of June. Let the transaction be there, and then we'll fix the matter after 8th of June.
On that day, he also agreed to pay on 8th of June the remaining amount.
I see.
No, 8th of June is okay. Do you want to fix the matter on 8th of June itself?
On
8th
that
of
day, my lord, he can pay in the court. On or before he can pay, or on 8th of June, the matter may be fixed, my lord. already, my lord, the chance was given to them to deposit in the registry, my lord. So that, my lord, on 8th of June, the matter may be fixed, or before 8th of June, he can pay, my lord. We are available here. And we will,
Today, 50,000 has been given, my lord, that may be, no, but through online, my lord, to my friend.
already he has paid rupees 50,000 in her account.
Why
On-
before, or not before registry? Because order is per order by coordinate bench.
Earlier, that was, my lord, that was earlier, that was paid, so.
Do it before registry because the order of the court was that the day before registry should be there.
Because, my lord, entire amount he is not managed to entire amount, therefore, my lord, before the registry.
No, it's okay, I can understand. You, whatever the 50 lakhs, you could have paid to registry. Rather through the account of the council, you can pay. Or you could have paid. Anyway, hard Mr. R. Ali Dilane
HM.
Oh, sorry. H.A. Ahmed Dilane Consultation Oscar. MS Mr. Kuria Dilane Consultation respondent number 2. And Mr. E.S. Dr. Dilane additional people in states. It is submitted, Mr. Ahmed, that during the pendency of the criminal appeal, matter was amicably settled, and the petitioner is ready for the payment of the payment, and in that context, he had already paid rupees 1 lakh to the respond number 2 and respond number 2. However, for direction of the this court, he today have paid through online made an online payment to the discount of the respondent number 2, and remaining 3.5 lakhs will be paid within 8 of June. So it's next MS Dilane Dilane account for the respondent number 2. So submitted that the rupees 1 lakh that has already been received by the respondent number 2, and the remaining she has the respondent number 2, respondent number 2 has no objection. If the remaining amount is 3.5 lakh is deposited on or before 8/6. Next, in view of this, petitioner can hereby directed to make the payment before reached on or before 8/6. And the matter may be fixed on 8/6/2026 for necessary. Or the next, let's go with you. If we listing it on 8/6, try to manage, try to keep the
My
deposit
lord,
by.
matter is fixed on 8th, my lord.
Yes.
Oblast.
May I be heard?
Yes.
Lordship, in this case, the respondent number 2 is the wife of the petitioner. And the petitioner is an army personnel, Lordship. He is posted in government. Then, Lordship, the response, Lordship,
An army person.
army person. The respondent number 2, Lordship, filed a domestic violence case under section 12 of 12, Lordship, of the DBA before the Judicial Magistrate First Class. And on, Lordship, 25/11/2021, Lordship,
20.
the 25/11/2021, Lordship, an interim order was, maintenance order was passed in the domestic violence case, Lordship, DB case. And on the same day, the respondent filed another case under section 125 CRPC before the family court, suppressing the fact that the DB case is pending and she has got an order. Now, Lordship, after receiving the summons from the Lordship family court, petitioners appeared, Lordship, but he could not, Lordship, file the WS, Lordship. He could not file the WS, and on 28/3/2022, Lordship, the case was, he was absent, Lordship, and accordingly it was proceeded
8-3.
ex parte,
F3.
28/3/2022. Thereafter, Lordship, this impugn order was passed on 17/11/2023. The impugn order, which is before challenged before this court. 17/11/2023. Lordship, the entire proceeding, Lordship, the main, Lordship, effect is that, Lordship, the quantum in this case, Lordship, family court finally, Lordship, by this impugn order, Lordship, awarded total 20,000, Lordship. 15,000 for, Lordship, wife, and 5,000 for, there is a minor boy, Lordship, for 5,000 for this boy, Lordship. So the entire case proceedings, Lordship, neither the petitioner claiming the maintenance, a respondent claiming the maintenance, nor the petitioner as a respondent filed their affidavit of disclosures of assets and liability, which is
Both the
mandatory.
parties.
Both the parties. And the quantum is determined on the basis of a salary slip submitted by the respondent before the court. So my respectful submission is that because of suppression of the DB case, subsequently what happened, Lordship, the DB case was also finally disposed of. And in the DB case, the award was, he was awarded, Lordship, total, Lordship, 3,000 for rent, 10,000 for maintenance, 3 lakhs as additional compensation, which is to be paid monthly 2,000. So accordingly, in the DB case, he is to pay 15,000 monthly, and here, Lordship, in the family court order, he is to pay 20,000. So because of this suppression, this happened. If the affidavit of assets and liabilities are submitted at the beginning, that cannot be happened, Lordship, and there may be a, Lordship, balance between the, my respectful submission is that when the petitioner approached this court, this honorable court directed to the petitioner to pay monthly 50% of the maintenance order which was awarded. That is 10,000 monthly. He was also paying, Lordship, the petitioner. Now, Lordship, may I pray one thing, Lordship? This matter may be remanded, Lordship, with the direction to the petitioner as well as the respondent to file the respective assets and liabilities of disclosure of assets and liabilities affidavit, Lordship. And thereafter, Lordship, the learned court below may be determined it a fresh lot. Then it will be, Lordship, helpful for the petitioners as well as the respondent, Lordship. Otherwise, it means the amount, the petitioner's income, Lordship, I have collected the recent lordship, the seller slip. Okay. Well, his salary, monthly salary, which is regularly credited in his account, 69,000 lordship. And if he among his lordship 35,000 is to pay lordship, then it will impossible for him to maintain other liabilities. Lordship. So both the parties may disclose their liabilities before the court, and lordship within a limited period, lordship, the matter may be the amount of the, the maintenance under section 1625 may be lordship determined. This is very aspect to submit.
Yes. May please, Lordship. In this case, what happened, Lordship, after stay order from this court, Lordship, he was very irregular in paying the maintenance amount, Lordship. Only 10,000 he was directed to pay per month, but in Lordship, normally 4-5 months after he paid the amount. And now also yesterday I have been informed that from January till date, no maintenance amount was given by the husband, Lordship. Wife is living with a son, and there is no it is settled that in under both the acts, lordship, the wife can sought for maintenance. He did not contested the maintenance case before the family court. After appearing there, he sought for time for filing written statement. Thereafter, the petitioner remained absent, lordship. So the family court proceeded ex parte to decide the matter. As assets and liabilities were not submitted by both the parties, wife lordship obtained a salary certificate, and that was submitted before the learned family court. And learned family court held in the impugn order that 60,000 is the salary of the petitioner. So accordingly, that amount was granted by the family. Let him satisfy your lordship that due to some reason he was absent from the family court. While I have filed my objection annexing all the documents, that the days where he absent in the family court, he was contesting the DB case. See, he waived his right to contest the maintenance case. In my objection petition, I have stated paragraph 4 of page 68. Some allegations were leveled by the petitioner. Those were denied in my objection, lordship, in paragraph 4, 5. And he made some wrong statement that one FIR was lost by paragraph 6, lordship. That the deponent begs to state that the statements made in para 6 and 7 of the petition are all false statements. There was no such incident happened, but the family members of the petitioner, just to harass the family members of the deponent, lost the aforesaid fabricated case. It is to be mentioned herein that the statement made in this para by the petitioner that the said FIR was charge sheeted and the same is pending for trial is completely a false statement. But in fact, the police submitted final report number 4135 dated 31/10/2022 against the said FIR. The petitioner and his family members harassed the deponent, and as such, the Silchar PS case number 2075/2021 was filed against them, and the same was charge sheeted as charge sheet number so and so. Therefore, this false statement made by the petitioner in this petition itself shows that he is not before this court with clean hands, and lordship, he wants to drag the court's attention that he is an army man, lordship. But in this case, while he was contesting the DB case, he refrained himself from contesting the family court case. He himself admitted in this petition that he sought for time
The petitioner sought for time to filing written statement, and thereafter on last 3 dates he remained absent. That also I have mentioned. Para 8, Lordship, that the deponent begs to state that the statements made in para number 9 and 10 of the petition, the petitioner stated that while the FC criminal miss case was fixed on 12/1/2022 for filing of written statement, he on that day filed petition seeking time to file written statement, and prayer was allowed, fixing the case on 28/2/2022 for written statement. But on 28/2/2022, as he was absent and could not file his written statement as he had to report his place of posting, the case was again fixed on 28/3/2022. But as he was not aware about the fixation of the case on 28/3/2022, he remained absent, and accordingly the case was decided ex parte by order dated 17/11/2022. It is the case of the petitioner that as he did not engage any advocate, he remained ignorant of the status of the case. In that context, the deponent at the outset begs to state that in a proceeding before the family court, engagement of advocate is not permissible. However, the petition dated 12/1/2022 filed by him appears to have been filed through an advocate. So that is another wrong statement given by the petitioner. And as such, the statement made by the petitioner that he did not engage any advocate is completely false and misleading. That while the Learned Family Court passed the order dated 28/3/2022 to proceed the case ex parte, the applicant was in Kashmir, and thereafter he was transferred to some other places and eventually to Ladakh in the month of July 2023. And during that period, he could not avail leave. As a result, he was totally unaware about the progress of the case. In other words, the plea of the applicant is that from 28/3/2022 to July 2023, he was transferred to various places, and as such, he could not get any leave and remain out of station. But the very statement is totally false and misleading, inasmuch as on 14/7/2022 and 1/9/2022, the applicant was very much present in Miss DB case number 271/2021. Those orders I have enclosed as Annexure A. Page 75, Lordship. '75 and 76, order dated 14/7/2022. Aggrieved is present along with her counsel. Respondent number 1 is personally present, whereas respondent number 2, 3 are absent with petition number so and so. Considering the ground, their absence is condoned for today. So on 14/7/22, he was personally present before DB court. And 1/9/2022, page 78. Aggrieved person is present along with her counsel. Respondent number 1 is present, and other respondents are present by their counsel. So on both these dates, Lordship, he appeared before the Learned Family, Lordship, Executive Court. Paragraph 9, I have stated that the deponent begs to state that as the case was very well known to the petitioner, as he has appeared before the Principal Judge Family Court and also engaged a counsel who has submitted wakalatnama, which is on record, the case went ex parte on 28/3/2022, and the final judgment came on 17/11/2023. In between, 2 notices were issued by the Honorable Family Court to the petitioner for reducing salary certificate dated 3/12/2022 and 23/2023. One ground was taken by the petitioner that Lordship, had it been a case family court issued a notice, he would have been placed that notice before his employer, Lordship, and then he could avail the leave from the service, Lordship. So in this ground also, Lordship, there are two notices were sent by the family court for producing the salary certificate. That was also not, Lordship, contested by the petitioner. After this judgment, he filed a matrimonial appeal along with condonation application. I have filed my objection before the division bench. Then division bench held that the matrimonial appeal is not maintainable in maintenance cases, Lordship. When the order passed by family court in maintenance cases, matrimonial appeal is not applicable, Lordship. So
Just
that,
let us one.
Lordship,
There is no bar at all to seek maintenance in the before DP court, as well as for the concerned magistrate
when family court pass an order, Lordship, revision is like matrimonial appeal is not
No,
maintainable.
no, I'm not. Now, but whether the person can be asked to make payment in both the matters in
Yes, Lordship, there is no bar, Lordship. There are lots of judgment which says a wife can sought for maintenance under both the acts. There is no bar.
No, there is no bar.
No bar.
But whether he can be, I mean, directed to pay maintenance in PV case as well as at the same time.
Under
maintenance is-
125,
Ah.
she can pay.
Ah.
So this order was passed
No,
under
other orders, that is suppose compensation or rent is questioned or her accommodation is concerned. That can be passed under TV 12 of the DBA.
Yeah.
I'm asking that suppose 15,000 is ordered by a DB court also, and another 15,000 or 20,000 or whether he is liable to liable to pay both.
Lordship, then his duty is to inform the DB court.
But you have suppressed the matter.
Yes.
No, Lordship.
Yes, Lordship.
Lordship, we have filed the DB case. He was present before the learned DB court. He can inform the court that in the meantime, maintenance was already given by the family court in maintenance case. That ground is required to be placed by the petitioner before the DB court, Lordship.
Appear before the court with and suppose
Lordship,
if
he
the order
appeared
is
and
already
contested.
there, because when the interim order was passed on that day itself, you have filed one DB.
Yes, Lord.
Yes.
So seeking again some maintenance and other relief.
Lordship.
Other relief is okay.
Lordship, there is no bar. He can inform the court that I am already paying 15,000 as because he was not paying any money under 125 petition. After appearing before this court, when this court, Lordship, granted stay, directing him to pay the 50% of the amount, then we filed execution petition and the petitioner taken a ground that High Court already stayed the matter. So, Lordship, we are directed to pay 50%. But the learned executing court is saying that when High Court already granted stay in all the area amounts, now onwards you pay 10,000 per month.
So area is still
Area still remain. There is a stay by this court, Lordship. In area there is no direction to pay. Only after granting stay order from this court, he started paying 10,000 per month. That is too very irregular, Lordship. As I have stated, Lordship, yesterday also I have taken information that since January no amount was paid. So after instituting 125 petition, he never paid anything. So we have filed the DB case. In DB case, not a single penny till date he paid. The interim, the final amount, nothing was paid by the petition.
We have not paid anything.
No, my lord.
For DB court also.
They first they filed the DB case, and against the final order of DB case, the petitioner filed the appeal before the session judge. Lord. So it is not pending. I do not know.
Pending.
Yes, pending, Lord. So and man, from
Lordship, till
my line
hearing to final order, not a single penny paid by the.
but
His conduct is very bad.
against this, the appeal is pending. And my contact, Lordship, kindly give me 1 minute time, Lordship. After getting the interim order, direction of this honorable court, petitioner, in the record it is available, Lordship, petitioner filed an application, Lordship, taking application, Lordship, that is on 7/1/2025, Lordship, taking a pay along with 10,000, Lordship, but they did not receive, Lordship. They
did not receive.
They did not receive.
No,
They say, Lordship,
thereafter received, Lordship.
they,
they've
Lordship,
done.
they say that, Lordship, they, Lordship, on thereafter, Lordship, they are willing to file objection on this petition. They file objection. It is available in the record, Lordship. They file objection, and thereafter what happens? After filing the objection, then a hearing was took place. Thereafter, Lordship, finally, when the executing court, Lordship, directed, decided that as the Honorable High Court decided the matter and passing this stay order and directed to pay 50,000, that not, I cannot modify this order. Then, Lordship, they are trying to accept this 50,000. We have 50%, Lordship. And in the meantime, some amount was, Lordship, area, Lordship, which was subsequently the petitioner submitted, Lordship, before the court, Lordship. And receipts was also there, Lordship, which is also I have submitted on earlier occasions, Lordship, before this honorable court, Lordship. And only what happened, my learned friend is, senior counsel is saying that, Lordship, from January, Lordship, he is not paying, Lordship. He is paying, Lordship, as there is execution tweet is there, and there is some dates are there. And every date he has submitted this amount, Lord. So for that purpose, Lordship, so far as my instruction, Lordship, 2 months is there, Lordship. Whatever amount, Lordship, my respectful submission is that there is clear that the mandate of the Honorable Apex Court is violated in this case. So, Lordship, there is Lordship, no bar.
Suppose that a part is entirely against the DPA case is pending. No,
Yes,
issue with
Lord.
that. Now, here admittedly, you have also admitted that SSL evidence was not produced.
Not
At the
produced.
time of filing
As
the
Lordship,
passing
the-
order, it was an ex parte order.
Ex parte order.
And by that time, most probably WS was also not there, giving an opportunity to pay those, to furnish those SSL lab.
That ex parte order was not challenged by the petitioner. The final order was challenged.
Yes. Final order was challenged.
That the family court said that the proceeding will proceed ex parte. That was never tried to be vacated by the petitioner. That was not
It was never
challenged
challenged.
before the Lordship final. It attained finality. So the final order they have challenged.
Yes, final order they have.
Lordship.
So they are saying that if an opportunity without interfering the amount which was directed by this court,
Yes.
about 10,000 per
Yes,
month,
Lord.
without interfering that amount, can the matter be remanded with the direction for fresh disposal by, obtaining the sellers? He
Assets
have
and
to pay the seller certificate. It's okay. Now, as he has submitted that he is drawing most probably net how much?
I have to submit a 69,000, Lord.
69,000.
Directing both the parties to submit the affidavit in disclosure, Lord.
Yeah, obviously
Yes,
disclose
Lord.
that.
Now my wife is also got a job in the private
La-
school or
no.
government school. Or
So far as my instruction, she is
He got a job suppose.
got in the private government school, Lord.
Because
Yes.
it a private job may not be.
Yes, yes.
maybe a
may not be
government
but
job. Lordship.
To some extent, it may help her financially. To some extent.
Yes, Lord.
So that has to be brought before the court.
Yes, Lord.
And they considering overall his liability, if any liability is there and all.
Yes.
So we can pass on by that order so that matter may be remanded back only to, but not the
Assets
other
and liability.
only
Right.
production of the SSI and to dispose of the matter accordingly by avoiding
Lordship.
whatever complaint.
Yes, Lord.
By complying the
Complying.
adherence, taking into adherence of the Rajneesh versus Neha.
Yes, Lord.
Yes, that's
Lordship.
because he is not now he is not in a position to, he is not challenging the interim, ex parte order, and most probably it is not their challenge also that she is not entitled, that these and that these are not the
Lordship.
criteria. He is only challenge is the quantum, maybe And that too the expertise. So let us five
Lordship, I am agreeable to that. Lordship, only record that on the day of his appearance, he should clear 10,000 per month as directed by this court. Whatever amount is due,
Yes.
only after clearance, his assets and liabilities
Will
may
be
be
accepted.
taken on record.
Yes, Lord. Yes, Lord.
Lordship, that-
I mean, but
and
area-
thereafter
area-
also he will regularly pay.
Area means
Area-
where you are saying.
Lordship, I am
means
saying
10,000.
from January to May.
All the
they have-
area maybe.
Yes.
Yeah.
That can be. That,
Yes, Lord.
because let the matter be finally
Yes.
Lordship,
decided.
by the time he Lordship produced the certified copy of this final order, Lordship, the May month will be completed. So January to May, Lordship, he has to pay the amount before the
Whatever amount Lordship is area,
January.
Lordship,
50% of the as Honorable High Court directed, and later on, if any judgment is passed on the basis of assets and liabilities, and if I am entitled for 20,000, then he will pay the entire amount as per that final order.
Very
So
area. We'll pass the order here in the at 2 p.m. Just remain present. If anything is left, just let us. Simple order will be passed considering your submission.
yes.
apply.
Well,
Thank you. Yes.
My lord, item 13, my lord, item 13, 13, my lord.
1-3.
1-3, my lord. My lord, the opposite party counsel has expressed some difficulty, my lord. He's ill, my lord. Therefore, he is unable to.
I Talukdar is dead.
He was on behalf of ISL.
You are appearing.
Yeah.
So you
Next
have
week,
some
any-
difficulty.
Some difficult. Next week, any day.
My lord, on 26th, my lord, Tuesday.
The matters have already been fixed. Somehow we are Mr. T. Imtiaz. Mr. You are Mr.
B. Hussain on behalf of I.
P. Hussain appearing on behalf of Mr. I. Talukdar. And it is submitted by Mr. Hussain. Some personal convenience. Mr. Talukdar is not. In view of this, 2nd of June will do. The matter according to 6. Is there any interim question of interim
No, man.
in the admission? We're listing it on check.
Deeply of it. My lord,
Yes.
item number 12,
Item number?
12 admission matter,
Yes.
today's list. Can it be taken up day after tomorrow? In the second half, I have some personal difficulty.
Day?
Day after tomorrow? On Thursday or on,
Sorry, this, so we are busy.
on next week then? I have to leave for Arunachal Pradesh, Itanagar today. 12.
Lordship, I have filed my letter of absence tomorrow to 30 of May. So if possible after 30. I just file my letter of absence.
Yes, my lord.
After 30th of May.
After 30, I will be available.
Maybe as per your convenience, either first or third. Because second is a hearing day, no.
Yes, Lordship.
Yes.
Date not
Any
be
date.
fixed. Will be possible on first or third.
Lordship, first week of June.
No, first week of June. Or you want any fixed date? Just one I'm asking.
On either on
Oh,
first
yes,
or
Lordship.
third, my lord.
Yes, Lordship. Third.
3-6.
3rd June.
3rd June.
Yes, Lordship.
Matter is that. Parts on as Yes. A.M.S. Mazumdar done for the Ms. Archer did an incident counsel. MXSE Raja and respond. This application has been filed under section 58 BMSS. Dated section 19, section 4 of Family Courts Act 1984. Read with Article 227 of the Constitution of India, challenging the correctness and legality of the impugned ex parte order dated 17/11/2023, passed by learned Principal Judge Family Court, Achal Silchar, in FC bracket of criminal case number 42/2021, whereby the learned Principal Judge Family Court had directed the respondent number 2. Directed the petitioner to provide the respondent number 2 wife, the bracket of the 2 wife, monthly maintenance at the rate of rupees 15,000 per month and rupees 5,000 for her minor son. That is rupees 20,000 per month with effect from date of passing the order, that is 17/11/3. Mr. Mujumdar, the learned counsel for the petitioner, submitted that we are submitting the interim order in DV case was filed on 25/11/21. Prior to the disposal of this list.
Yes, yes. Lordship, on the day of 25/11/2025, DB interim order was passed. 21, Lord. On the same day, they filed. Lord.
So it's submitted that present petitioner is an army personnel, and the respondent number 2 had instituted a DV case in section 12 of the DV Act. 12 of the DV Act, seeking monetary as well as the other reliefs. And the learned trial court below, in the said DV case number.
Lordship, DB case
number is
DB case number is, Lordship, page 7, paragraph 8, I have mentioned. Lord. Paragraph 8, page 7.
Page 21, Miss DB case number 271/2021. And order dated 25/11/2021 is also there.
In page number?
Page number 21. Annexure 1.
I get. In 21, passed an interim order dated 25/11/2021, directing the present petitioner to pay rupees
2,500.
And rupees 2,500, that is rupees 1,000 for the agri person bracket of respondent number 2, and rupees 1,500 for their minor child. Minor child. So interim, as per interim, only 2,500 was granted.
Right. Subsequently, it was finalized, Lordship. I have stated in second annexure 2, Lordship, page 23. Annexure 2, page 23.
And finally, annexure to page
23, Lord.
And after final hearing in the DV case, the
Amount of 10,000 in round 3, Lordship. 6,000 for the wife and 4,000 for the minor child.
Page 23, Lord.
Finally,
2, 3,
as per
4.
the final order, the maintenance was granted to the tune of rupees 6,000 for the respondent number 2 and 4,000 for their minor child. If further submitted on the day when the interim order was passed, that is on 25/11/2021, the respondent number 2 instituted another petition for the maintenance before the learned principal judge family court.
Over the family court, page 25 is the page 25, Lord. This is the
court, family court
application
Kasar
filed under
Silchar-
section 125.
Kasar Silchar seeking maintenance, seeking monthly maintenance from the present petition. And the said maintenance case, the petitioner had appeared and they sought time for filing his WS. But on next date of listing, that is on 28/3/2020, he remain absent, and the WS was also not be filed by him as he had to leave for his place of posting. Considering his absence, the matter proceeded expertly and by order dated 17/11/2025. The expertise and by the expertise order dated, the expertise of the impugn order dated 17/11/2023. The order of maintenance was passed, directing the petitioner.
It is the final order, Lord.
Directing the petitioner to pay an amount of rupees so and so for the petitioner and so for their minor child. Next, he further submitted that at the time of passing the order, the petition was also not supported with any any affidavit of assets and liabilities, which is required as per the guideline of Honorable Apex Court, passed in case of Neha versus Rajneesh, and the petitioner respondent, then the petitioner was also not given any opportunity to file his assets and liabilities and the documents. Thus, the order of maintenance was passed in his absence on 17/11/2023, directing the respondent, directing the petitioner to pay maintenance as stated. Next. Mr. Muzumdar, I have submitted that he is the marriage and the paternity of the child is not the disputed fact, but without giving opportunity and without period of any assets and liabilities, the order has been passed by the learned Principal Judge by the learned Principal Judge, Family Court, Achar Silchar, only on the basis of the salary statement which was produced by the respondent at the time of the hearing. However, he submitted that accordingly, he submitted that that matter may be remanded back to the learned trial court below, learned trial court below, learned principal judge, and authorized order may be passed in regards to quantum of the maintenance after appreciation of the assets and liabilities, the assets and liabilities of both the parties, giving an opportunity for filing the assets and liabilities by the parties. Next. MS. Next, MS Chaudhary, the learned senior counsel, submitted in this regard that there cannot be any bar for paying for maintenance before the court of before the court under the DB Act as well as under the Maintenance Act. And the petitioner never approached the DB court with the view that the maintenance has already been granted under the in the case of maintenance which was instituted before the family court Kachar Singh. She further submitted that the though the petitioner remained absent and did not file his WS, but he was appealing before the court of JMFC where the DB case was pending, and ignored and did not and intentionally did not appear before the court of Principal Judge Family Court to proceed with the case of maintenance. He further submitted that the salary certificate was produced before the learned Principal Judge Family Court, and on the basis of which the order of maintenance was passed by the learned court. However, she admitted that SSN affidavit on SSN liabilities was not produced before the court at the time of hearing or at the time of passing the order by the MS Chaudhary further submitted that though this court had passed the order for paying maintenance of rupees, paying maintenance 50% of the awarded amount, paying directed to pay for 50% of the awarded amount, that is 10,000 per month, but the present petitioner is very irregular even in paying the 50% of the awarded amount. Since last 2-3 months, he has not been the maintenance, he has not been paid to the respondent number. But what is the order of 14/7/2022?
For
In 76, I have annexed 14/7/2022. What is it? I mean, his expertise order was vacated or?
no, Lord. Lordship, there was a direction on 2/12/24, Lordship, regarding the
It was before DV. Oh,
before
achha,
PPT.
achha. So on 14/7/2022, he was appeared before the DV court.
DB case, but remain absent
remain
in
absent.
125 proceeding. They have stated that they were posted in somewhere else, Lordship. Just to show that he was present at Silchar on these 2 dates. He was representing in DB case, but refrained himself from appearing in the family court.
Mr. Choudhury further submitted that from the order passed by the learned JMFC in DB case, it dated 14/7/2020. It reveals that he was very much present in the Silchar station of Silchar, and considering his prayer, the expertise order passed in the say DB case was also vacated by the learned trial court. Full stop. Thus, it is seen that in spite of his presence in the Silchar town, he remained absent in the maintenance proceeding, for which the matter proceeded expertly against him. So,
So my humble submission before your lordship on these grounds that he showing that he was absent, he could not contest. On this ground, his petition may not be allowed to represent himself before the family court and file a written statement after his lordship. Only he may be allowed to contest the family court case by submitting assets and liabilities.
Yes, I'm
okay,
thinking.
that
Yes,
should
that's
go down.
Lordship.
That it is further. Further, she submitted that though the final order passed by the principal just communicate regarding the maintenance is put under challenge, but there is, but the respondent, but the petitioner never challenged the order of expertise passed against him, and he never appeared before the learned principal judge with and that sort of application for vacating the expertise order passed against him. However, however, MS Choudhury submitted that he may be directed to furnish his assets and liabilities before the learned principal judge for assessing the maintenance allowance, and in that case, the respondent is also ready to file her assets and liabilities before the learned principal judge family court in the as per direction of the Honorable Apex Court passed in case of Neha versus Rajnis, which is also reiterated in the case of Aditi is subsequent or
yes,
prior?
subsequent, Lord.
Reiterated in case of Aditi alias Mithi, Secretary Supra, reported by 2023 SCC Online SC 14. Next paragraph. No, none. Same paragraph. MS Choudhury further submitted that in spite of the direction of this court to make payment of rupees 10,000 per month, the petitioner is very irregular in paying the maintenance, and accordingly she submitted that a direction may be given.
2023.
A direction may be given to the petitioner for to make the payment of entire period from January 2026 till he appears before the learned principal judge for submitting his assessment liabilities. Next paragraph. Considering the submission made by the council proposals, it is seen that the marriage and paternity of the child is not under dispute. And in the same time, it is also seen that the petitioner did not challenge the order of ex parte order of maintenance, ex parte order passed against him. However, this challenge that the final order of maintenance dated 17/11/2025 has been challenged, wherein the petitioner was directed to pay and amount of rupees 20,000 towards monthly maintenance, that is 15,000 for the respondent number 2 and 5,000 for permanent child. At the same time, it is also seen that at the time of passing the final order, the learned principal judge did not ask the party to furnish their assets and liabilities, and only on the basis of the salary statement produced before the court, the order of maintenance was accordingly. Next point. In view of this, and also considering the view of the Honorable Apex vis-a-vis the submission made by Honorable Council proposals, present the both the parties are hereby directed to appear before the learned principal judge family court Silchar and Silchar on when will be our convening
Lordship,
date?
a date may be fixed
Yeah,
after.
that's what I'm saying. What
After 1 month, my lord. He was to come before from the Kashmir law.
in that date?
A date fixed, maybe.
Right? Let it be on 15th June or
15th
15th will be okay.
Lordship,
15th June. maybe.
15 June, Lordship, and before that, the LCR may be sent back.
Yes.
Yes. LCR, we have only, it is LCR.
LCR is there, Lord.
I mean,
Scan copy or
scan
LCR?
copy.
No, LCR.
Original. Original.
Original, Lord.
Okay, then let it be on 18, exactly
18.
after 1.
Lordship.
Directing both the parties to appear before so and so on 18/6/2026 with their assets and liabilities, and the petitioner is also hereby directed to make payment of the maintenance as fixed by this court, that is 10,000 per month from January 2026 till he appears before the learned principal judge. Scan copy of the TCR, scan copy, the TCR be accordingly returned back. Rest will do the needful. With the above. Okay, then we are directed to 18/6, and you are also directed to make the payment up to May 2026.
Yes, Lord.
January to May, make
Yes,
clear all
yes.
the payment. And
On
then after
18/6, Lordship.
on
On
18/6,
18/6. If he does not pay the amount, then Lordship, the earlier order will revive.
no, obviously that
He will pay, Lordship. He will pay.
Lordship, that
will
may
pay.
be the
This
clear,
area pay, he'll pay, Lord.
Lordship is setting aside the earlier order. Lordship.
Yes, Lord.
earlier order. Now we are setting aside the
Yes, Lordship.
17/11/2023 may be set aside, Lord.
accordingly the order of earlier order dated 17/11/2026 filed by the learned principal judge family court so and so is hereby set aside with a direction to pass a fresh order of maintenance considering the assets and liabilities to be furnished. Assets and liabilities to be furnished by
Both parties may be furnished, Lord.
yes, both parties. You make payment up to May and then
Lord.
Lordship, may kindly record that if he did not pay, Lordship does not pay, then the earlier order will survive, Lordship. Otherwise, Lordship, he will not pay. He is
He will
not
pay, my lord.
regularly
He will
paying.
pay. He will pay. He has paid
cannot
matter up
be-
to December, lordship. No problem. He already paid, lord. Only
Ask him
few
to
months.
pay. He's a salaried person.
Yes.
Somehow, if there is any adverse order is there, or
DBK's Lordship is
fact, there is a provision of issuance of NBWA also. So
Lordship.
no, go.
He will
no,
pay, lordship.
please
He will
don't go to that extent.
So far as my lordship,
Yeah,
he
pay.
will pay, lordship. He will pay.
We'll see.
public.
It is about. We'll see. As your return.
Interim order earlier that may be vacated.
Interim order means what?
No, as per the
10,000 we are directing. to pay
Continue, Lord.
10,000. So, interim order, it vacated means it will be again create some,
Yes.
create some problem also.
No,
It will be.
Lordship is
Obviously, it is
aside,
the,
setting aside the original
then
order.
in that case, it has.
Only till May he will pay, and thereafter, after May, Lordship, within 3 months, the family court will decide.
Decide the matter, yes.
Then thereafter, whatever judgment will come, if anybody challenges his okay.
That there is the liberty will be there.
দাদা হবে 3 months ভিতরে ডিসপোজ করবে লিকুইড আর interim, what was the interim as a stay?
50%, the judgment was stayed on the basis
Interim
that
order,
he will pay-
interim order passed on 2/12/24, lordship. 2/12/24, that the 50% of the maintenance amount will be paid by the petitioner until further order. This was the order. So therefore, lordship, 10,000 is going, giving,
So
he is giving 10,000.
18/6 he will pay the amount, and thereafter the family court will take its course to decide the matter afresh on the basis
No,
of.
no, I'm not on that. I'm asking that if suppose interim was there for 10,000, obviously when we dispose of the matter, question of
Yes.
existence of interim is not there.
Yes.
Not-
However, I make a observation that 10,000, what is the
Yes,
will pay up to so and so, and then it will be.
yes, lord.
That will be better, otherwise a confusion will arise again.
Tapi for note এটা দি থওঁ, মই লাইনটো দিয়া নাই যদি মই দি দিম পিছত 10,000 will be paid এনেকৈ লিখি দিয়ক, মই মিলাই দিম হা interim vacated rate দিয়ক 10,000 may be paid in dispose. It's a pair to my okay.
Apply, lord.
Yeah.
Wait, please, Lordship. Also, we have taken a step of not respondent number 2, Lordship.
I am appealing for respondent to.
That's from
And the thing is, my lord, here, my lord, we have objection to the appeal. Because he has filed the appeal directly to the Honorable High Court. Under the
Directly?
provision. Yes.
Acha.
Judgment has been passed by learned judicial magistrate against acquittal, acquitting the, my lord, respondent. Now against that, he should have either filed directly appeal, my lord, under the BNSS to the Court of Session. Now he has filed it here, my lord, but he has not sought for any leave. His leave application is also not. So that
So
is
this is the against acquittal.
Yes, Lordship.
Leave is not there.
in a check bounce case. No leave has been taken.
No, it's a victim, I think. Victim leave is required. No, not required.
Required, my lord. I have a judgment, my lord.
No, for victim leave is not
Yes,
required.
my lord, 419. He has come under 419 BNS. Had he been come under 413, my lord, then he could directly, my lord, file appeal before the session judge without any procedure of seeking leave.
No, when victim is appearing, in that case, whether leave is necessary.
That provision says, my lord, 419, he has filed a petition, my lord.
419 may be wrong provision.
419 of BNSS. So may I read your lord? Page 2. Or 19 subsection 4 your. And that is supported by one judgment. Subsection.
Doesn't come later on, just come to statute first. What it says.
Yes, ma'am. 419, my lord. Sub rule 4. No,
if such an order of acquittal is passed in any case instituted upon complaint and the High Court on an application made to it by the complainant in this behalf grants special leave to appeal from the order of acquittal. The complainant may present such an appeal to the High Court. Now, number 5, no application under subsection 4 for grant of special leave to appeal from an order of acquittal shall be entertained by the High Court after the expiry of 6 months, where the complainant is a public servant, and 60 days in every other case. So here is 60 days in a private complaint. There apart, my lord.
The 413 could have come, I think.
413, he could have filed in before Honorable Session Judge directly, my lord, without any procedural limit of seeking leave. That judgment is.
Lordship, kindly fix another date, Lordship.
Because this is the order against passed by magistrate only.
Yes, Lordship.
Cannot directly come before the High Court. Otherwise, you have to approach the one forum, that is session judge.
Yes.
Okay, then you think over it and submit before us. Because it is may not be maintainable here at state. Because you have directly come before the Honorable High Court against the order of magistrate. Maybe for acquittal, whatever. Or 413, you could have come by 413. Session. Not required, not required. No, but he or she, whatever, he be victim of this case. So in case of victim, under 430, no. Otherwise also, whether under 419, they can directly come or the before session. Directly come. Under 141. A victim can directly come. No, under 419. Before High Court or what, or before session. Because if the order is passed by minister, otherwise we are not on other. You can directly come. Just read. Just read. Leave, they are not sought for leave.
419P.
Yes. No, 1 and 2 is different. You by learned PP or by, in that case, most probably leave is required.
Incognizable.
Hmm.
But here he has not filed any leave matter along with his condonation. of 60 days period is mentioned. 60 days in a private complaint.
Hmm.
So in one of my case, my lord, in Delhi High Court, my lord, in such circumstances, remanded the case to the session court.
So, but 413 is there for victim or complaint.
413, my lord, my humble submission, he can directly, my lord, without seeking any leave.
Yes,
he can directly file.
He can directly file.
But why he has come in High Court, my lord, then he has to take leave. That leave is within 60 days. Now he has already for 6 months. More than 6 months.
Think of it. You may
Yes, Lord.
come directly for session judge.
Yes,
Under
Lord.
413.
Kindly fix another date, Lord.
Even without leave. Even with.
Yes.
Yes, yes.
You can withdraw here, my lord. Liberty may.
Just let us know on the next day. We are not
Yes, Lord.
discussing it today by itself. But may not be maintainable. That's what. At that point, there is no leave application here. Okay, list on yes, when can be listed as per your convenience.
First week of June, Lord.
First week of June.
First of June.
1st of June will. First of the request made by direct the list matter.
My name may be recorded. B. Borua for responding.
B.
B. Borua for responding.
B. Borua. You are Mr. Fupan.
J. Hatimuria.
Huh?
J. Hatimuria.
J. Hatimuria. Third Mr. J. Hatimuria. PS Topper, United Distance CP, number 1, and Mr. B. Purva, the learned counsel, already entered into evidence. Request made by the learned counsel for the evidence matter is adjourned. List matter accordingly on 1/6.
Like
My deposit matter be adjourned for the time being.
Now, what is it? It's in order column only.
Yes, sir.
Yeah, are you going to submit anything?
I don't know. Sorry,
I'm sorry.
No, it's okay. No issue. Why it is in order column, Mr. Chaudhary?
I don't know much. Actually, it is revision, my lord, sir. That's why I think.
Pardon?
It is a revision petition, my lord.
No.
Washing.
Why it is in order column?
probably for service of.
Notice is
Yes, notice
evidence.
was issued, my lord. Notice of CD was called for, my lord. LCF.
Also call for.
Yes, your lordship order is there, my lord. Kindly see, my lord, your lordship's order dated. It is dated 27/2/26.
Yeah. So case diary was also called for, na?
My one of the cases, my lord, that earlier he was.
Respondent number 2 already appeared.
Notice.
Probably not mercy because mercy his no one his name is there. Respondent's name not shown.
No name.
Now office note, office.
Office note is there then.
It's
Surprising.
whether it is
One Abhijit Neog is there for the informant.
Yes, with the informant.
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 You have taken steps only.
Yes.
So that service is awaited, I think.
Huh?
You have received the case diary here?
No, my lord, this year, accordingly, let the case diary be called for from the IO.
It is still
This is the matter on so
investigation, I
that
think.
that is your lordship.
Calling for the case diary only.
Yeah.
that we have not received will be.
On the 3-4 dates already gone.
Yes, I have.
Yes.
It's not yet served. Let them notice the served.
No, notice whether the office note, my lord. I'm sorry, it could not be taken on agreement. Go on.
Can you make any inquiry in that regard regarding the service of notice on respond number 2? Because Mr. One Abhijit Neog, he was the informant.
If it is the steps has been taken to the OC concern, then we can take the instruction. But otherwise, it is difficult for us to.
Which is this speed post is difficult
My
for you,
lord,
but they have taken steps through speed
office note,
post.
why not, whether anything is reflected,
Speed post. It is only because there is speed post.
speed post. It was sent.
It was sent. It was.
Service review awaited.
Otherwise, just see his address is informant so and so daughter, resident of anti factory and vigilance officer, Assam, Council of Medical.
Yes.
So
Yes, which was given in the
but yes, obviously the name is there. So whether you can be able to represent him, Mr. Law, or no?
But we are not representing them because this is some other department or some council of medical that is present. We are not. If it is the officer in charge, inspector of the police station, then we can represent them. But it's not. He is being.
only thing notice has gone, not returned, not come. That is, I think, my lord.
Not return. So that's why I thought that if you that may be abated, but in the meantime, if it can be sent through jurisdictional OC of the jurisdictional police station, in that case, we may make a direction to the not direction for a request to the additional PP to make an inquiry in regards to service. That will make to some extent easier for us. So let us by maybe abated and the CD will be called. Ask or intimate your the IO to send this case diary because obviously it is 2-3 days has already been gotten. Okay, heard Mr. H.R. Chaudhary, the learned senior advocate, assisted by Ms. R. Dekha, the learned counsel for the petitioners, and also heard Mr. P.S. Tongkot, the learned additional PP, every state respondent. Office note dated 16/5/2026 reveals that the service for this respondent number 2 is still awaited. Let the
Yes, sir.
service be awaited till next date of listing. However, it is felt necessary to issue notice to the respondent number 2 through officer in charge of jurisdictional police station. And the learned additional PP is also hereby requested to make an inquiry in regards to service of notice in the event of issuing notice. Further, the IO is hereby directed to furnish the case diary on or before the next date of listing. Next date of listing matter accordingly. Yes, he is resident of respondent number 2 is from
Who is here, Gauhati, man?
He today only can take the today or by
Should we take steps, my lord? Steps is not required.
steps through
Whether step is,
OC of the judicial police station so that they can make an inquiry. Otherwise, speed post the.
so we can submit the petition to them.
No, not to them. You just send it. Additional PP or the office of the public prosecutor will make an inquiry regarding this service.
If not, if not comes on the next day.
Yes, OC of the concerned jurisdiction.
Yes, it will be GS code Gauhati.
That means
OC
dispute
Kunho,
PS.
GS
Will
code.
be under dispute PS, I think, or what? And dispute PS.
There are so many police stations.
Huh?
There are so many police stations in Europe.
Officer Directorate of Medical 6 mile.
GS road, GS road. This is its official address. Oh, no. Residential address is also. Office of the Director of the Medical. Huh?
First number PS is Dubri, but man is the respondent 2 is from here, mile.
No, respondent number 2 is from here, Gauhati.
Gauhati.
Yeah. And Office of the Directorate of Medical 6 mile. Directorate of Medical 6 mile. GS road, GS. Hey, GS road to put for you.
There are so many cars in Persista police station. There are then dispute police station. One part is wrong.
Under dispute.
Hello. Office of Directorate of Medical Minor.
6 mile hole. Director of Medical. No. The car under this station.
Very dispute over anything. Normally dispute.
Please to over there.
Director. Assam Council of Medical.
Hey, 6 mile to 4 under police station. Jagirot 6 mile Jagirot.
This poor model, I think it will be this poor. 6 mile.
Just verify it may be this 4 also.
This.
Maybe this 4.
If your lordship make this poor, if there is anything, we'll immediately.
No, we are
Can be one thing can be done. It may be sent through the that is the SSP and this is DCP East. Then it will be covered in entire.
To DCP East.
DCP East.
Sponsor
DCP East.
DCP East. Who said? DCP East. OC. OC of the.
She got it this poor police station.
True. DCP East. Okay, then through DCP East.
Yes. DCP East now West.
East.
East. East
Will
Gauhati.
be East only. This DCP East. When it can be fixed.
Huh?
When it can be fixed.
But only because 340 is already gone, Myra. A date.
That's what I'm
June 10 of June. Or CD has to come.
From Dubli.
10th of June.
No, CD has to come.
No, CD already information there. Both our CD is called long back. 4 months back.
We have sent
3 months back.
3 times requisition.
Tell us 10th of June or.
Already 73 years man, he used to go to the court, my lord. Proceedings.
One, eh? Yes, why not?
So why he didn't go the war? It turned over August 2008, if possible, my lord.
4th of June or 5th of June, maybe at
As your lordship.
4th, 5th of
5.
5.
All right. Published.
Please, your lordship. Lordship, this is a part-heard matter.
Yes.
Just come up, and your lordship would recollect on the last occasion, the respondent side had raised one issue as regard to the nature of the order, which we are challenging this before this honorable court by way of a revision. Now they contended that this is nature is an interlocutory order which cannot be challenged by way of a revision. They have cited one judgment.
Not one, my lord, three judgments,
Yes.
my lord. One full bench judgment of Honorable Supreme Court. Another judgment from Honorable Supreme Court, my lord. And there is one Honorable Calcutta High Court judgment, my lord. Yes. Whereby
Just I want to just for non this. There are item number 35 and 37, na? Item number 35 and 37. Is anyone is there for item number 35 and 37? 37. It may be a John there. We'll hear the matter, please. 32, 33, 30.
I fix a date.
Hearing date. First week of June, any hearing date?
We'll take a great lordship at the possible because enactment of lordship. That is
No, may not be possible. There are other matters we have already top of the list is there. What to do? It's a hearing day Tuesday. Tuesday hearing. Second. It was number
37.
You are for 37?
Yes, 37.
Second. 35 is anyone in there? Is anyone? None? Sir. Okay, you can start.
Yes.
So that was the issue you have submitted that. No, 35 is not related to you. Someone just wait. Let us see. You can come by relax for some time and then you come. Just make an inquiry. I don't know. I have not seen. That's why we are calling for the 35 also, but they are not here. Anyway, so he had already furnished three judgments. Submitted
of the apex court that the nature of the order passed under section 311 appears to be an interlocutory order. Therefore, revision is not maintainable. That was the plea. And under such circumstances, the matter was kept parted. And to address that particular issue, Your Lordship, I would like to furnish a judgment. A very recent judgment, Lordship. It was reported in 2024, One Law Herald, SC 114.
Basically, it was an order of 311. Na?
Yes, not 311. For Your Honor, because the judgment which he preferred, it's
No, I'm not. Your particular case is there against the
311 order, yes. Whereby three numbers of cases were there connected to the same subject matter of dispute arising out of a case of a negotiable instrument set. Therefore, my petition for calling a witness, for recalling a witness under 311 was rejected. Agreed by which I filed a petition under 397 or Adbit 401 of the CRPC seeking for setting aside, modify, or any such consequential orders as this honorable court may deem fit and proper. Now, the plea which they have raised is that revision is not maintainable. But I would like to cite a judgment, a very recent judgment of 2025 One Herald's SC 114 copy. Akansha Arora and Tanay Maben. In this judgment, Lordship, the apex court has the ratio which has been laid down here is that an nomenclature of a petition is immaterial. Here, if Your Lordship comes to the para number 10 of the judgment, apart from para number 8 and 9,
wherein the scope of section 482 CRPC and section 3C97 CRPC is laid down. In para number 10, viewed in the light of the above precedents, we feel that even if the High Court was of the view that appellant should have invoked jurisdiction under 397 CRPC for seeking an enhancement of interim maintenance, it ought not to have been non-suited the appellant only on the ground of alternative remedy. Judicious approach would have been to convert the petition under section 482 CRPC into a revision under 397 and have to be decided as per law.
My lord, may kindly note that. My lord, may kindly note that what Honorable Supreme Court is stated. 482 petition may be converted into revision, my lord. Not revision petition converted into 482.
Now here the thing is, Your Honor, since we are agreed by said order, we are here for setting aside. Now the nomenclature states that we have come here by way of a revision. But in that plea which they have taken, on that ground, my case should not be non-suited because it is for the interest of justice. The imperative lies upon this honorable court to convert such petition into a 482 as we have prayed for. Maybe by its own promoto it can convert it, or by way of an application we file, praying that should be converted. Because the grievance which we have taken up and the remedy which we are seeking is for setting aside said orders and for calling the said person as witness in connection with the case. This is my submission as regard to the plea which they have taken, that the said 397 is not maintainable, but it is clear that nomenclature is immaterial. Even in Lordship, in other cases, also conversion is done, Lordship, because the nature of relief is quite same and identical as we have prayed for here. And our case is therefore calling of the person as witness, because the crux of the matter is that the excess amount has been taken up arising out from a land sale dispute. And in the course of evidence also, the three brothers were there, one brother. Together they have taken a major part of the sum. And unless we call him up before the trial court to tender his evidence, we cannot prove our case. That is my submission in the merit of the case. And so far as to the plea of non-maintainability of such petition, this judgment supports my submission, which I have prayed, which I have placed, that this same can be converted. This is my answer.
Lordship may kindly allow to reply. My lord, I have submitted 3 authorities, one by the Honorable Calcutta High Court, clearly saying that 311 orders are interlocutory orders, so hence a revision petition is non-maintainable, which is backed by 2009 judgment passed by Honorable Supreme Court, my lord. In Seturaman's case, I have supplied the copies earlier, my lord. In Seturaman's case, also the Honorable Supreme Court has clearly stated at paragraph 5, my lord, that if an order passed on an application under 311 CRPC, my lord, that is purely an interlocutory application, and against that order, my lord, revision petition is clearly not maintainable. Further, my lord, probably what my learned brother has relied, division bench. My lord, it is a settled position of law, my lord, an authority laid down by a superior court, my lord, always have the binding force, my. Here, my lord, I have last time submitted one judgment, my lord, in the case of Girish Kumar Suneja versus Central Bureau of Investigation, reported in 2017, 14 SCC 809, my lord. I have last time submitted a copy to the Honorable Court, my lord.
Girish Kumar.
Girish Kumar Suneza versus
yes.
Central Bureau of Investigation. 2017, 14 SCC 809. Here, my lord, kindly come to paragraph 27. This is a full bench judgment. Judgment passed by 3 judges, my lord, of Honorable Supreme. Your lordship has got paragraph 27, my lord. May I read it, my lord? On our conclusion on this subject, that while appellant might have an entitlement, not in bracket, not a right to file revision petition in the High Court, but that entitlement can be taken away, and in any event, the High Court is under no obligation to entertain a revision petition. Such a petition can be rejected at threshold. If the High Court is inclined to accept the revision petition, it can do so only against an final order or an intermediate order, namely an order which, if set aside, would result in culminating the proceeding. Here, my lord, 311 order, if set aside, my lord, it doesn't amount in culminating the proceeding, my lord. It is settled law, my lord. In fact, in 2009, Supreme Court judgment, my lord, Seturman's case, that same thing has been explained by Honorable Supreme Court, my lord. As we see it, there appears to be only such eventualities of a revision or revisable order, and in any case, in any case, only one such eventualities is before us. Consequently, the result of paragraph 10 of the order passed by this court, it is court is that the entitlement of the appellant to file a revision petition in the High Court is taken away, and thereby High Court is deprived of exercising extraordinary discretionary power available under Section 397 CRPC. Then, my lord, may kindly, what my learned friend trying to establish that if it is barred under Section 397, that Honorable Supreme Court, this Honorable Court can exercise extraordinary power under 482, my lord. In this same judgment, my lord, the full bench of Honorable Supreme Court has explained that at paragraph number 29, my lord. May I read it? Paragraph 29, my lord. This led us to another facet of the submission made by the learned counsel that even the avenue of proceeding under Section 482 is barred as far as the appellant are concerned, as held in Amarnath and with other and with which conclusion we agree. This is the language of the Honorable Supreme Court. We agree if an interlocutory application is not revisable due to the prohibition contained under Section 397 CRPC, that cannot be culminated, circumvented by resort to Section 482 CRPC, my lord. This is the opinion of Honorable Supreme Court, my lord. If there is a bar under Section 397, my lord, 482 cannot come into recourse of. This is my. And this case has the binding effect till date, my lord, because this judgment has not been set aside by coordinate bench or any other larger bench, my lord.
No.
And in fact, my lord, what my learned friend has submitted a copy of the Honorable Supreme Court.
Supreme Court.
Yes. Here, my lord, order passed under Section 125 under sentence, I think. Yes. Both proceedings are different, my lord. In that case, my lord, the Honorable Court, Section 311 was not in question, my lord. That clear-cut judgment, my lord, in fact, in view of this full bench judgment, my lord, in Girish Kumar Suneja's case, my lord. Bar under 482 also applicable, my lord. If there is a bar under section 397.
Now, Lordship, for a moment in the judgment would come to para number 7. Para number 10 I've stated earlier. Now, para number 7. This court has in a cantina of decision provided that the nomenclature of a petition is immaterial. For doing substantive justice, the High Court can always convert under Section 480 to a revision under 397 and vice versa. The approach of the High Court in dismissing the petition filed by the appellant under Section 482 on the hyper-technical ground that she was always availed the remedy of a revision cannot be appreciated because the same has unnecessarily compelled the appellant to approach this way by way of this appeal under Article 136 of the Constitution of India. Now, the point of maintainability has been raised at the hearing stage, admittedly, at the hearing stage. So, now, if in such circumstances, Your Honor, if we pray that why not this petition may be converted, then what would bar me from not converting it? What would bar me from seeking such the prayer which I have put before this honorable court? What would be the bar on me? Because for doing substantial justice, for the purpose of the substantial justice only, I am praying that the petition should be converted. This is my prayer, apart from the merits of the case. So this is my humble submission, Your Honor, because this can always be converted, and the entire gist and crux of the matter is only for setting aside, challenging the impugneness of the order. By way of a 482 application also, Your Honor, if we go, ultimately we are challenging the said order only. Nothing more than that. 397 also for the purpose of setting aside or modification of the order. This is the case.
My lord,
This is what I have put, because a case on a hyper-technical view should not be rejected, Lordship. This is my submission, and this is perhaps a very recent judgment on this aspect.
My lord, will definitely go through all the authorities submitted by me as well as my learned friend, my lord. I think, my lord, in the judgment authority relied upon by my learned friend, my lord, Girish Kumar Suneja has not been discussed, my lord. Authority laid down by a superior bench has not been discussed, my lord. In the latest judgment relied upon by my learned friend, and he does not have the power to overrule what Girish Kumar Suneja has stated. Honorable Supreme Court has stated in Girish Kumar Suneja, my lord. Apart from that, my lord, last time I have not gone through the merit of the case, my lord. Only one textual point I may be allowed to point out, my lord. Apart from the maintainability question, my lord. My lord, may kindly come to item number 32, my lord, page number 50, my lord. Item 32, my lord. Criminal revision petition 400/2023, my lord. Page 50, my lord. This is the 311 petition, my lord, filed by the petitioner. My lord, it is a settled position of law. 311 power can be exercised at the time of before delivering the judgment. That is a settled position of law. I cannot dispute. However, the Honorable Supreme Court has categorically stated, my lord, such power should not be exercised to fill in the lacuna. And even, my lord, in this petition, my lord, I have not found anywhere. Kindly see, my lord, in the order itself has reflected that after recording the 313 statement, the petitioner was given chance to submit DWs, my lord. But through a petition filed himself, my lord, he has withdrawn. He stated that I will not file any defense witness. Then the case was fixed for hearing. So, my lord, under what circumstances, what new thing has come before him, which made him to realize that this petition is necessary? At that point, only Mr. Anil Das, no? Anil Das. Payment to Mr. Anil Das was not in my knowledge. Whether anything has been stated in the petition, my lord, I don't find anything. This is clearly a glaring example of, my lord, afterthought, my lord, only to delay the proceeding. The case is fixed for hearing, my lord. There is no explanation that I could not have access to payment made to Mr. Anil Das, my lord. In fact, my lord, he has said that I have paid Mr. Anil Das. Anil Das is the co-owner, my lord. If I have paid to Mr. Anil Das, why earlier I do not? I refuse to adduce evidence. I refuse to produce Mr. Anil Das as witness. This is my humble submission. And further, my lord, regarding filling up of lacuna, my lord, whether Section 311 application, how Section 311 application can be exercised, that has been stated in a recent judgment, my lord, where our Honorable Gauhati High Court judgment was under challenge before the Honorable Supreme Court, my lord. While the Honorable Supreme Court upholding the judgment passed by our Honorable High Court, my lord, held that if, my lord, that is, my lord, in the case of Neha Begum and others versus State of Assam and another. Relevant portion will be at paragraph 8, my lord. Paragraph 8 is 4, my lord. May I read it, my lord? On perusal of the subject application filed the petitioners in the trial court by invoking provision under Section 231, subsection 2, read with Section 311, we find that other than vague expression that erstwhile lawyer engaged by the petitioner did not conduct proper cross-examination of the witnesses, no such specific ground was allowed on behalf of the accused petitioner, which could be considered to be a valid ground for trial court to invoke powers under Section 311 CRPC. Apparently, thus the prayer made by petitioners in the application to recall and re-examine the witnesses was nothing but an attempt to fill in the lacuna. There is nothing on the record suggests that non-summoning of witnesses. So ultimately, what our Honorable Gauhati High Court has stated, that has been upheld by the Honorable Supreme Court. This is the latest case law, my lord. And here also, my lord, your lordship has perused the application filed by the petitioner in the before the trial court, my lord. No explanation was given why he could not produce Mr. Anil Das before. Only vague assumption, presumption will not allow, my lord, the petitioner to get the benefit of Section 311 CRP. This is my humble submission, my lord. I humbly pray before this honorable court to consider my submission made before this honorable court and reject this petition. Deeply.
Now to Lordship, I may be allowed to submit a limited submission.
Continuing process. It will be continuing process. Then. How many times will allow to counter?
Last and limited submission on the part last on the merit on the part of merit. Now the petition which we filed was to summon Anil Das as a witness. Now it is not that we haven't stated the ground depending on which, if your honor peruses the application, the averments were made. What made the accused person to call Mr. Anil Das as a witness in the case? That reasoning has been already stated in the application, but it is on the part of the trial court which did not find that said application to be tenable. As such, we are before this honorable court on the facts and circumstances of the case which we have already raised before this honorable court. And your honor, this is the settled law that the cardinal rule in the law of evidence that best available evidence should be brought before the court. An accused, for the purpose of setting up his defense,
Best available evidence, my lord. Kindly
should
remember.
not be disallowed or disregarded in the course of the proceeding to prove its case. And so far is the lacuna which he had raised, whether such lacuna is a irreparable lacuna. Can it be termed as an irreparable lacuna, which is a fall of out of an oversight? So therefore, under such circumstances, laches or mistakes, whatever it may be, cannot be understood as a lacuna which a court cannot fill up. In such case, I would not read out the ratio, lordship, but I would like to rely on a judgment on 2019, 6 SSC 2003, Manju Devi versus State of Rajasthan, wherein the point of section 311 has been laid down in para number 9 and 9.1. This one judgment, I would not read it out, lordship. Much time it will take because these are big paragraphs. The ratio of the decision, which I would like to raise. It is in para number 9 and 9.1 in support of my case. And one more judgment, that is 1991 SSC Criminal 595, para number 10, Mohanlal Samji Soni versus Union of India. This is paragraph number 10. I rely. For my humble submissions, considering the facts and circumstances of the case, lordship, the said person should be allowed to be called as a witness in connection with this, lordship. This is my humble prayer.
We're going to reserve the case.
Interim may be continued till delivery of
Interim Need to continue now. No, the interview will not continue now. We pass the order.
Allah.
I'm deeply deep.
We can Is the matter okay? 35, no one is here. So it was an appeal, right? But they are not appearing. The matter of 2012. I thought that if someone appeared, this remaining maybe remain as a part, but they have not.